Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 11th, 2025. We have 7 bills on the voting list, and we're going to start off with Senate Bill 1001. Senator Mouts, welcome.
Thank you, Mr. Chair, Mr. Vice Chair, colleagues. It's an honor to be here with you this afternoon to present Senate Bill 1001, the PACE Act. This is legislation that I believe you heard last session. It's my first time presenting this bill. I'm blessed today to have Professor Lucius Outlaw in the audience to help out with any specifics, and I also have Adam Holofcener. I messed up Adam's last name, but he's with the Maryland Volunteer Lawyers for the Arts. The PACE Act is straightforward. It deals with a case from the Maryland Court of Appeals, Maryland versus Montague, and it clarifies what First Amendment evidence can be used in a criminal prosecution. And it does that by creating a 4-prong test. The first prong is literal versus figurative. Is the content literal or using artistic license? The second is facts matching the allegation. Is there a fact pattern connecting the art to specific allegations? The third is area of dispute. Is there a fact being disputed, or is it already stipulated by the defense? And then the last prong is value not provided by other evidence. Since this is a First Amendment protected gray area to begin with, it's a distinct probative value not provided by other admissible evidence. The rules of evidence is an incredible class in law school, which I did not prosper in. I survived it, okay? But to break this down and surmise what we're talking about is you have musical lyrics, and I was going to use a hypothetical. You know, I woke up this morning, maybe I made a song, right? Johnny wrote a song, published a song, and the song, you know, included a bank robbery. And if I were to write a song and there was a bank robbery and the robbery matched exactly what happened, where my song said I woke up and, you know, my dog ran away and my car wouldn't start and my girl left me, and so I was out of money, and so I went down and, you know, I used a certain firearm and I went to a certain bank and I took a certain amount of money, and lo and behold, I published this song, and guess what? On a certain day in my hometown, those facts occurred. Well, that song would be admissible in the prosecution. And what's happening now in culture, in First Amendment, in music, in all genres of music, real life scenarios are played out through emotion and through creativity. What can happen with reality is sometimes those creations can be used as evidence in court. And so this act, the PACE Act, is set just to clarify what is admissible and what is not admissible. The PACE Act does not say that music is not admissible. It just clarifies what has to be proven in order for it to be admissible. It was heard again. It was heard last year. We're presenting it again this year. We hope that the committee will be able to find it. And it's hard to give this bill a favorable report. And again, I'd like to repeat that Professor Outlaw is here to answer the specific questions, because we do not want a repeat of my evidence class from law school. I do not want to put you through that. So, colleagues, thank you.
Excellent. Thank you very much. Senator, questions from the committee? This bill engendered a lot of debate last year. Cold bench? Questions from the committee? Okay. Thank you, Senator. No questions from the committee? Okay. Excellent.
Innocent.
All right. Senator, thank you very much. All right.
Oh, no. It's not. And I might want to ask your law professor, because I don't want to put you on the spot. I really don't, Senator Mouts. So identify, this did engender a lot of discussion last year, and I'm sure it's still just as fascinating. I don't remember what the criteria is now for allowing such creative expressions to come into court as probative, I suppose, of a criminal conduct. I guess that's what we're talking about. But I assume generally, evidentiary-wise, the the creative expression has to be probative, so you do have to go through that exercise. So tell me what the flaw is now under our rules of evidence and how this bill will help prevent whatever you think is the failing of our evidentiary rule today. That's what I'm looking for. And don't you want to answer that, Senator Mounds? Don't you want to do that?
Thank you for that question,
You're
Senator.
welcome, certainly. Yeah, oh, yeah, yeah,
First, you're absolutely right. All evidence must pass a relevancy bar.
right.
And then even relevant evidence must pass the bar that it must be more probative than
more
prejudicial. And so there are rules of evidence. The problem is that the rules of evidence as currently constituted are not sufficient to protect artistic expression, particularly rap lyrics that are being used as evidence. Now, why is that?
Yeah.
One is that because there's really no clear guidance as to what is, when it comes to artistic expression, particularly rap lyrics, what is relevant and what is probative and not unduly prejudicial. And to give you an example, Maryland has Rule 5-403B, which basically says that you can't use character evidence to show somebody had a propensity at the charge, right?
Right.
You can't say, well, they're known as being a violent person, they're charged with violent crime, therefore they're guilty.
With a million exceptions.
Millions of
You know
exceptions.
that.
Exactly, that's where I'm going to.
I did do well in evidence.
Yes, and one of the exceptions is if that other bad act shows knowledge that is connected to the criminal offense, right? You've done something in the past that shows that you know how to do
Yeah,
that criminal
yeah.
activity, and that's the activity that's charged here. The problem is when it comes to rap lyrics, knowledge is so broad in general that there's no real clear guidelines. There are actually no boundaries. So you have instances where somebody has rapped about drugs, the general subject, and then they're charged with distributing drugs. And courts will say, well, they rapped about drugs. That means they know about drugs. Therefore, those lyrics are relevant, probative. And that, obviously, that's just going too far. Just because somebody raps about drugs doesn't necessarily mean they know the ins and outs of drug dealing. There's no limits, really, on saying what knowledge is. And that's why this bill is so important, because what it really does is prosecutors want to use these lyrics essentially as confessions. They want to say, you rapped about this, you're basically confessing to this crime. And what this bill says is like, well, if you're going to use it as a confession, it needs to meet confession standards, meaning that the rap lyrics must match with the facts of the case. That's all it does. It's saying, if you want to use this to say this person committed a crime, then those lyrics have to contain facts that are specific to the crime charge.
Can I ask, I
Sure.
don't mean to interrupt, but I'm reading, it has to be literal rather than figurative. I find that to be a little broad myself. I get where you're coming from, I do. So I'm not just playing devil's advocate here
Sure.
a little bit, but it's literal versus figurative. What are you trying to say there? What you just said, I kind of support. If
Right.
the fact, if the lyrics are very specific.
Right.
It's Tuesday, March 17th, and I went down to
Yep.
the da-da-da-da,
Yep.
and I did da-da-da. And then the crime happens and this person's charged with it.
Right.
I think it'd be hard not to
Right.
allow that in. So how is that what you're trying to get at with the language, literal but not figurative? And could we make that a little tighter and follow what you just testified to?
Sure, I'll leave it to you all to draft language, but I'll give you an example that's commonly used. Johnny Cash shot a man in Reno to watch him die. Now, let's say later Johnny Cash was charged with murder, right? But the murder happened in, Idaho, right? You wouldn't say, well, that lyric should come in because he talks about shooting. That was figurative, right? He's making a point. It's not a literal, I actually shot a man to watch him die. That's what it gets at. It's like, you can't say that somebody's using metaphor or symbolism to try to say, it's like, no, there has to be a literal connection of facts from the lyrics that are connected to the facts of the case. It cannot be general subject matter. It cannot be somebody using metaphor to prove a point. It has to be a literal connection between the facts of the lyrics and the facts of the case.
And as I recall from last year, my last question, I believe, but I'm not certain, that this language may have been passed in other jurisdictions. It may only have been introduced, I really can't remember. So the question is, has this language been adopted in other courts, probably in other states, in other evidence, with rules of evidence? And then, if so, the second question would be, how's that working out?
So I can't say that this exact language has been
Okay.
used,
Fair
but
enough.
similar bills getting to the same subject of protecting artistic expression, particularly rap and hip hop expression, one has been passed in California. There's bills pending in Georgia. One was passed in Louisiana. Georgia, there's a bill. There's New York, there's a bill that's been pending. Even at the federal level, one has been introduced over and over again, hasn't passed. So the movement is there.
Got it.
And it's coming. And we're seeing it in some of the case law in around the country.
Right.
There was a big case in New York recently involving, it was actually the murder of a prominent rap person, Jam Master Jay. It was a drug deal gone wrong, and the government wanted to use the lyrics of the person accused. And the judge said no, and went through like the history of rap, why this is important, and why there needs to be protections.
Doesn't that prove the point that we don't need the bill? I mean, judges can then use their wise discretion to say, look, just what you're getting at.
But the problem with it is that
That's
case law precedent can change tomorrow.
true.
And that's the other problem, is that we can have one judge in the same jurisdiction say no, and another judge say yes, and then there's no clear guidance, right? And also, case law can change in a moment. One judge, one appellate court can say, I disagree with that, and we're going to change it. And so that is the problem. That's why a rule is needed, to have consistency, clear guidelines that everybody understands, everybody's working from the same page, and just won't change tomorrow.
Thank you. Thank you, Mr. Chairman.
All right, further questions from the committee? All right, seeing none, thank you very much, Senator. Thank you, Professor. Thank you.
Thank you.
All right, with that, that'll conclude the hearing for Senate Bill 1001. We'll now go on to Senator Attar with Senate Bill 1011.
Thank you, Mr. Chair. Let me just pull out the right bill. Okay. Senate Bill 1011. Thank you, Mr. Chair, Mr. Vice Chair, and members. Dahlia Attar here in support of Senate Bill 1011. As many of you may remember, a couple of years ago in Surfside, Miami, we had a very tragic incident with a condominium where I believe over 90 people died. In 2022, there was a bill that you're all aware of to address this and make sure a tragedy like this does not happen again. The result of that was we have many condominium owners throughout the state of Maryland who are really struggling with the fees they are now being assessed as a result of these deferred maintenance funds. So originally, as this bill was drafted, it would create a fund that would help those low-income condominium owners pay these fees, and it would run through DHCD. But taking into consideration the fiscal year that we're in right now and what's going on with our fiscal and our budget, we changed the bill both in the House, we have an amendment, and in the Senate, and you should have that amendment before you. But this amendment strikes the entire bill and instead creates a study. And you ask, why do we need a study? We know this is a problem. The study is to examine specific things like the age and income level of unit owners, the date of the most recent reserve study for each building, and overall the goal is for us to be able to come back and say, you know what, yes, we do need a grant fund, but it needs to be targeted this amount of money, so it can target the people, let's say, over 65 years old, people with this income and below. So the idea for this bill is hopefully we can have a study, we can pinpoint what exactly we need this funding for and who it can help the most, and then we can come back next year with the original bill as drafted. And with that, I ask for your support. Thank you. No questions?
Questions from the committee? Oh, Senator West and Senator James.
Thank you, Mr. Chair. I think the idea of a study makes a lot of sense. This is not the only bill that we've gotten this year about these reserve funds. We seem to be inundated with bills about reserve funds. There's a lot of controversy about them. And maybe, is your study contemplated to be broad enough that the people studying the reserve funds could come back with a panoply of recommendations to us to deal with all elements of reserve funds?
So I don't want to speak on the other bills because I haven't analyzed the other bills that you have. My answer would be yes, this study should hopefully study it all so we can come back with a solution. But if you're telling me there are other bills that fixes this problem, I'd say pass those bills. We just want to pass a bill that fixes this problem and helps all of our constituents who are struggling with paying these assessments now.
I wonder if Lisa May is in the audience. She was representing Maryland Realtors. They submitted testimony. I see not, okay. I was hoping to get her to say that the Realtors would sign on to such a study.
Understood.
Thank
They're
you.
signed up favorable with amendments, but I don't see amendments. It's written only, yeah, but they're signed up favorable with amendments. I'm saying, I'm looking at their letter, but I don't see amendments. But
Okay.
we should engage with them after the hearing.
Okay, thank you.
Senator James.
Oh, thank you, Mr. Chairman. Yes, I think we all remember that terrible tragedy in Miami, and I have dear friends, many dear friends in Florida who are reeling from, the assessments they're dealing with. Just remind me one thing, Senator. Did we pass anything in Maryland initially in response to the Miami collapse, which is why we're having a worry now that a
Yes.
lot of people can't afford it? Could you just remind me of
Yes,
what we
so
did?
in-
Because I feel like we might have inflicted our own problem, and now we're passing a bill to solve our own problem. I'm wondering if we just shouldn't retract what we did before and recalibrate where we're going.
Thank you, Senator, for the question. So I'll comment on the second part of what you said first. We don't want a tragedy like that
Oh,
to
no, no,
happen.
no,
So I
that's
understand
assumed,
why we
that's
passed the initial thing. This is now, we need to perfect what we passed. So in 2022, we had House Bill 107, and that required reserve studies to be done for all the condominiums, which then ended up raising the assessments. But it was House Bill 107 in 2022.
Got it. That's very helpful. And then this, you may not know, and I hope this work group will address this, but ideally, the way condominiums work, and co-op ownership is that you're supposed to have a management board. They're supposed to be constantly vigilant about the common area maintenance, parking, garage. I'm a litigator. I've litigated many parking garage and, solid structured demise, if you will. And then keep up with it. And this is, there's a lot of regulations and requirements. So how would we have gotten to the point, if at all? Because I don't know if we're where we are in Florida, because Florida has a lot of salt water. I can imagine this might be true in Ocean City, but a lot of salt water, a lot of water in general, depends on where you are in the state of Maryland or even in the country as to what the concrete erosion, corrosive aspects would be. And they're different, very different. But anyway, back to how is it that the laws we have on the books now that are designed to keep up with maintenance, how have we fallen behind, if you know?
So that's a great question, and I can speak a little bit about it. What I can tell you is, I think we were all in a way asleep, assuming that everyone was doing what they were supposed to do and keeping up with it. Instead, what we found out, that there was a lot of deferred maintenance in all different condominiums. They were pushing off, fixing things, most likely because, and I can tell you as a prior unit owner, I didn't want to hear that, oh, we needed to fix this or that. I said, fix it later. We don't want to spend that money now. So that happened year after year, and unfortunately, it took a tragedy for us as legislators to come together and say, no, we need to do something to make sure this doesn't happen again. So in terms of what laws we have on the books prior to 2022 to prevent this, I don't know, and I don't know if we had any that would have prevented something like this, but that's why we're requiring now that all the unit owners, in 2022, do studies to determine what needs to be fixed. And that 2022 bill was pretty detailed in terms of what the study needs to cover, and that's why now we're seeing these huge assessments.
So in 2022, I apologize because I don't remember the bill, or I might not have been here, I can't remember. I guess it came in 2022. It seems to me there should be a standard that you can't defer certain maintenance, and you ought to have an expert outside of the board, really. The board should have some consultation with an expert that says, this is not the kind of thing that can be deferred. Is that what
Absolutely.
107 does?
So what my understanding of 107
I have
is
to look at it.
yes, and it requires that you not increase the fees, but it requires you take care of it, which as a result increases the assessments and the fees. So this is kind of a continuation of that bill.
Right.
It's saying, okay, we understand that's necessary. We're not saying get rid of what we did in 2022. We're saying now that there are these increased assessments, and right now it's saying, let's study so we can pinpoint exactly where can use the most help from us, basically.
Right, because what I don't want to do is
Yeah.
create a fund, and then it comes at taxpayer expense possibly, which I'm not sure that's how
Absolutely.
and then we're not addressing the chronic problem,
Absolutely.
because then it will just repeat itself. We'll pay for it, we'll ask taxpayers to pay for it one time, 20 years later, 10 years later, we find out the same
Absolutely.
condominiums, the same kind of people living there are not keeping up. So I am with my colleague Senator West that I hope we can pass a bill that's broad enough to take a holistic look at all of this. So I appreciate that.
No, thank you for the question, and I
Yeah.
do want to just leave off with, I think it's every 5 years a study has to be, the reserve study has to be done, but I may be wrong about
That's
that.
okay. Thank you
That's
so
what I
much for
think.
entertaining my
course.
questions. I appreciate it.
Excellent. Thank you very much, Senator James. Further questions from the committee? All right, seeing none, thank you very much, Senator. That'll conclude the hearing for Senate Bill 1011. We'll now move on to Senate Bill 1029. Senator Attar.
Senate Bill 1029, okay. Would it be okay if Mr. Morris comes up to the table just for questions? Or would you like to wait to see if there are? Okay. Okay, absolutely, thank you. Mr. Chair, Mr. Vice Chair, and members, thank you, Dahlia Attar here on behalf of, and I have the wrong bill, Senate Bill 1029, Estates and Trust Interpretation of Wills, Evidence of Intent, also known as Granny's Law. So unfortunately, this is another bill that I have to talk about that stems from a tragic incident that happened to a family, one of my constituents. So a couple of years ago, there was a will that was drafted at a certain point, and unfortunately, we all know when someone's deceased and wills go to the orphans court, they're interpreted certain ways. Unfortunately, the interpretation of this was not the way the family believes the deceased would have wanted. So for example, this person who wrote the will, which is Miss Johnson, who is in the room, and if everyone from the family can just stand up to show we have a lot of family members here in support of this bill. And Ms. Johnson has gone through a lot over this, and that's why we're here today. So her grandmother actually spent a lot of her life focusing on policies that lead to health-based disparities in the state of Maryland. And she spent her lifetime trying to fix these problems and no longer have health disparities. Specifically, what we see is racial health disparities. She then left a certain amount of money, a significant amount of money in the will to go to certain health institutions. And she did not specify that it should be used to address this, but the family knew this is what we discussed, this is what she spent her life on, this is what it should be used for. Unfortunately, the judge did not agree or did not want to listen to them or did not care, and instead said, no, we're not listening to you, and this is what's happening. So this bill is to address that situation, but to ensure that this no longer happens again to a family, and a family who is already suffering from a tragedy no longer has to deal with something like this. We're hoping to prevent that in the future. So this bill in general, what it does, and I'm just going to read for a little bit over here to tell you because there's a few things in it. So first, it authorizes a personal representative to petition the court to interpret a will based on the intent and decedent if the will, number one, contains a legacy for a health provider or charitable organization in the health sector and does not expressly provide that the legacy must be used to address health equity issues. So this will now allow for the family to bring in other evidence and say, wait, look at her lifetime of work. This is what she wants. This is how the will should be interpreted, and this is what we should do with the money. So we are hoping with this that we prevent future tragedies like that. And with that, I would ask for your support. And again, Mr. Morris is here for any specific questions, if there are.
Thank you so much for bringing the bill. Was not aware of this. What did the court ultimately rule? So and if there's, I guess if it may not have gone up on appeal, there may be no written decision. If there is, would you let me know the case?
So I'm going to step aside if it's okay, and I'm going to let Mr. Morris, who is intimately involved in it, answer that.
Hello.
Hello.
I asked the bill sponsor, I'm glad you're here, what was the court's ruling in the case?
The court's,
regarding the legacy.
the court's ruling was to read the will as she read it without allowing the extrinsic evidence.
Right, but what did that ultimately?
What that ultimately did was make the bequest to healthcare providers who were not subject to a restriction to address healthcare disparities. And to the extent that healthcare disparities persist, the decedent was put in a position where while she lived her life fighting disparities, the fruit of her life's work was to subsidize the perpetuation of those disparities.
Do you know what, could you reference a couple of the, wills are public information. What were a couple of the recipients of the request?
The American Heart Society, the Cancer Society, a mental health charity, and an Alzheimer's charity.
Okay, quite broad. Alzheimer's. And out of curiosity, since you were intimately involved, did any of those organizations make any kind of verbal commitment to try to honor, not so much enforce the will, since the will was silent on this, but did they make any commitments through the discussion about health disparities?
They made no discussion.
No discussion.
Yes, they simply ignored the family.
And finally, you know, having administered wills before and been a personal representative and then been a lawyer involved with them, it is, the laws on, in this area are pretty exacting. If, you know, you really read the intent of the decedent, they're not there anymore, and you usually don't go out beyond it. You bring up a very interesting circumstance here, but I guess what I'd be asking is, how would a person establish that the decedent wanted to do a particular thing versus that the decedent simply did want to generously give to healthcare entities?
Well, I think the way the statute was drafted, it contemplates, for example, lifetime's work addressing disparity, so that what we're looking to do is to align the gift with the work that produced the gift.
And here's my last question. It's a little unfair, but the devil's advocate. So if we were to do this bill, this would be quite a departure from existing law, not just in Maryland, but around the country. So what would we respond to someone who came to us? This is a narrowly drawn bill, which I'm sure is a very smart idea in some ways, to narrowly draw it to a particular circumstance. But it does lay open the door that someone else could come in with a similar issue, nothing to do with health, nothing to do with health disparity, but someone's lifetime work, their bequeaths are more general, and they would look to us and say, you did this in this circumstance, now repeat yourself and pass another law. How would we respond to the fact that we did a narrow bill, but it's a precedent, and we open up the whole sort of Pandora's box of everybody saying, well, this is what the decedent wanted, even though the will was silent?
Well, I think the one contextual consideration that we've not addressed is that this particular context of addressing health disparities is compatible with the declared public policy of the state of Maryland. So, for instance, in thinking about how you might address this, let's say that someone wanted to use or to confer a restriction that was contrary to public policy, let's say was by a Nazi who was
Yeah, but I don't.
wanting to do something
That's an easy one.
contrary
That's an easy one. How
public
about
policy.
something more general, like I spent my life caring for ailing and discarded racehorses. That's what I did with my farm. And then I just decide to give money to the Maryland Jockey Association and the breeders and a few others, but I don't specify that I want you to focus on ailing and neglected racehorses. And that is not against public policy, or it's probably a little bit consistent with Maryland policy. We do care about animals. How would I respond?
Well, I think this is a harsh response, which is
Fair.
you need a more general bill.
Yeah,
That's why this is narrowly tailored.
got it. Thank you. Thank you very much. Appreciate it.
Thank you, Mr. Chair. I fully understand the concern in this case, but I'm looking at the testimony of the Register of Wills of Baltimore County, and let me just read you a little bit of what she has to say and ask you to respond. It says, passing this bill will only serve to address the grievances of a single individual and upend centuries of settled case law dealing with the administration of estates. This would create chaos and uncertainty with estate administration and the interpretation of wills. As she continues and says, in this estate, the will could have been drafted to ensure that the gifts to charity were earmarked for purposes focused on eliminating health disparities based on race. And she concludes by saying this law would permit a personal representative to deviate from a testator's express instructions in a will. In other words, it would permit a personal representative's judgment to supersede the terms of a valid will. This is highly problematic. This law would permit the personal representative's notations of what a testator may have wanted in place of what the testator actually stated in a valid will. How do you respond to that?
Let's turn it around. Let us say that the testator wanted this particular outcome, and the lawyer did not properly draft the will, at least did not draft the will consistent with that particular interest. The family and the decedent are left out in the cold. And the question that I guess that's being asked is that where the law is, which says what should control is the intention of the decedent?
Well,
So all that, let me just finish this
Sure,
now.
yeah.
Mention that all that this is seeking to do is to create a forum where court can proceed to answer a relevant question and not just simply say, I don't see it in the will, therefore there's nothing for me to decide. This is leaving the issue to be decided.
Okay, so but this bill is a really, really narrowly tailored bill to deal with the specific situation as a result of a specific individual's death and a specific will executed by that individual before she died. Suppose we broaden this out. The principle you're trying to advocate for here is that any will could be attacked after the decedent's death by someone who says the decedent really didn't mean what the will says. The decedent really wanted the money to go for a different purpose, and therefore the Register of Wills should interpret the will inconsistent with the written language of the bill in order to give effect to that separate purpose. That would totally upend the rules of estate administration as we know them, would it not?
No, well, it would only do so when, in fact, that's the intention of the decedent that can be at least addressed by specific evidence of the decedent's life and the decedent's life's work. The issue here is whether compatible with the stated public policy relating to healthcare disparities, this particular decedent wanted their life's fortune to be used for that purpose.
I hear you, but the reason why we require wills to be executed with such slavish devotion to statutory requirements, witnesses, all that kind of stuff, and the decedent has to be there to sign the will in person, presumably is so the decedent reads the will and knows exactly what he or she wanted to be done with his or her assets after death, and in light of that fact signs the will in presence of other people. What you're suggesting is we should disregard the language of the will and use extraneous evidence to suggest that the decedent really had a different purpose in mind when the decedent signed language which didn't give effect to that different purpose.
Could I give a different slant on this?
Sure.
Going back to the problem presented by the declared public policy of the state of Maryland, that the decedent relied upon that policy to understand that what the decedent was providing was that the gift would be compatible with that policy. To the extent there is let's say, confusion relating to the intention. To some extent, the state of Maryland is complicit in that, in making something identified and declared as public policy. What this statute could be construed as, given its reference to public policy, is that it is allowing for that prospect and giving a framework where the issue can be sorted out. And it could be sorted out that that's the intention of the decedent, or it could be sorted out that that's not the intention of the decedent. But there is a framework by which that question can be addressed and not avoided because it's not relevant.
Yeah, but the bill goes into more detail. I don't want to debate the bill with you, but it says that once some evidence along these lines has been established, where is it here? Here he goes. A personal representative's presentation of evidence, whatever kind, it doesn't say what quantity of evidence, shall create a rebuttable presumption as to the intent of the decedent, and unless evidence is presented, I assume that evidence would not include the will, evidence is presented to rebut the presumption, the court shall interpret the will in accordance with the intent of the decedent as reflected in the evidence presented by the personal representative. It sounds like you're putting the rabbit in the hat and telling the court that the court has to interpret the will in accordance with the personal representative's presentation of evidence unless the decedent's family can come up with some other evidence to refute it. Am I wrong?
Yes, it does nothing unremarkable than to frame how a court makes a finding of fact. I think the objection would relate to any fact-finding framework that uses a rebuttable presumption.
Okay, thank you very much for your answers.
Thank you. Any further questions for the sponsor or this witness? All right, seeing no questions. Thank you, Delegate Attar. On that bit. Understood. Delegate Attar, next on our list. Yep. I'm sorry.
He's just saying Senator Attar, but it's okay. It takes getting used to.
Did I say delegate?
I'm still getting used to it.
I didn't even hear myself say it. I apologize.
I probably said it also.
Oh, I'm so
Yeah.
embarrassed. Right, Senator Attar, we can take whatever bill you'd like to do next. On our list, it's 10:30, but whatever.
Okay, we can do 10:30. That
Okay.
works. Okay, Senate Bill 1030, Dahlia Attar, Senator Dahlia Attar here in support of Senate Bill 1030. Thank you, Mr. Chair and members. Okay, let me make sure I'm on the right bill. Okay, so let's start with my son. My son, he's 11 now, and since he was about 9 months, he's had severe allergies to foods, a lot of different foods, and severe asthma. So I remember when he went into anaphylactic shock. I live in Baltimore City, and today I texted someone in city government who would know the answer, and I said, what's the current wait time, average wait time for an ambulance to arrive when someone calls 911? And he said many times it's up to 45 minutes. When my son was in anaphylactic shock, he didn't have 45 minutes. When my son stopped breathing because his asthma got so bad in the middle of the night, he didn't have 45 minutes, and an inhaler only lasts so long, just like an EpiPen only lasts so long. I am fortunate to live in an area that has volunteer groups that come together, they're EMTs, EMS, to help individuals that are in situations like this and emergencies like this. And I know throughout Maryland we have different groups like this. So there's one specific group that I know they brought this concern to me originally, and they're called Hatzalah of Baltimore, and they're all volunteers who come together and they respond to calls. They have a phone number, you can call them, they'll respond to calls. They even have several ambulances, and they'll transport you to the hospital as well. They also take calls. Baltimore City sometimes sends them calls to go respond to. Not sometimes, many times. I believe they respond to about, on an average, 1,800 calls a year. They've saved countless, countless lives. And I'm only talking about one organization. We have many throughout the state of Maryland. In about 2020, this organization went to the MVA and they said, listen, we have ambulances that have lights, but many times what's happening is, because we don't have enough ambulances, but we have a lot of volunteers, is someone would call us and we have people in their own vehicles that are responding, waiting for the ambulance, but are responding initially. And this is what happened for my son. They came, they had all their tools, everything they need, and they treated him. And then the ambulance showed up after that, within a couple minutes also. But they were able to get to my house very quickly. And that is because the MVA in 2020 said, yes, there's in the statute, it allows for rescue squads to have just lights, it's red or white lights on a vehicle that's responding to an emergency only. So since 2020, that's what they've been doing. There have been no issues, no concerns, for no accidents. They're trained to do this. But recently, MVA, we've had discussions, and they've said, you know what, it was brought to our attention that the law is not fully clear. So the authorization that we gave you, it's been written authorization for each vehicle that could have it. It's not fully clear that we can give that authorization. So you'll need legislation to be able to continue doing this. They did not revoke any of the authorizations that they gave. Instead, these individuals still have these lights that they're using when responding to emergencies. And it's only emergencies, I want to point that out. But they said, we'll let them continue doing it until at the end of session. Hopefully you can fix this during session. So that's why we have this bill here. And what this bill simply does is it specifies that these nonprofit commercial companies that are responding to emergencies can have these specific lights on their private vehicles. So this is not creating a whole new law. This is really just clarifying what was there originally to make sure that MVA has their clear authority to give these authorizations. Like I said, it's been the last 5 years. They've been doing this with no issues, and Baltimore City on a regular basis does call them to respond to calls when they're in need. Unfortunately, there's such a lag time from when an ambulance can respond. So I ask for a favorable report. Thank you.
Thank you. We'll go Senator Henson, and then Senator Folden, and then Senator.
And I do have with me Mr. Traubel's counsel for one of these organizations who can answer any specific questions.
Thank you, Mr. Chairman. Thank you for bringing the bill. I'm trying to understand the public availability of the bills cover, the vehicles covered under the bill. It looks like it's limited to Baltimore City and County. And then can anyone call and get this service, or how does it work?
So that's a great question. And first, it was originally going to be a statewide bill. And then speaking with the fire chiefs, they were like, listen, we haven't had this issue come up in different areas. We know Baltimore City and Baltimore County, it is an issue. So do you mind, just to avoid it becoming a statewide thing? And that's why we changed it to Baltimore City and Baltimore County. But I could tell you, myself and Senator Hedelman, the co-sponsor, we completely even forgot that it's only for those two counties. So we don't have the delegation letters yet, but we should have those hopefully by tomorrow. But they'll respond, and I could let you answer about where they'll respond to. But any call they get, they respond. Now, you can speak as to the radius as to where. I'll move over and let him answer the rest of that question, if that's okay.
Hi, thank you very much. So if I understand your question correctly, Senator, it's who else can take advantage of the services of this particular organization?
Yes.
As Senator Tarr said, first of all, there are similar organizations, volunteer organizations, all around the state. The bill was drafted because in the way it was, I believe, because the MVA brought up a question or asked us to come to you to clarify this because of our activities, my client's activities in and around Baltimore City, Baltimore County. We're in the 21209, 21208, 21117, Baltimore, Pikesville, Owings Mills area, and anybody can call. And we get calls, as Senator Tarr said, that we cover both in and for Baltimore City and Baltimore County, meaning the Baltimore City Fire Department and Baltimore County volunteer. There is not, more so in the city than in the county, in the city, there's a formal cooperation, meaning there are communications, radio communications that are shared. In Baltimore County, it hasn't gotten to that point yet. We're working on that. But anybody who's in distress and doesn't want to wait 45 minutes for an ambulance and would rather have a trained professional and an ambulance there within 90 seconds is certainly welcome and do take advantage of that. I don't know if that
Thank you.
addresses your question.
It does. I think then what it's leading me to is trying to figure out how you advertise, how people get access. For instance, I did undergrad and law school in Baltimore City, and I was there every day, and I never knew that such a service existed. If I had a medical emergency, it would have been great to be able to have a second set of numbers to call and to
Absolutely.
perhaps get help. How are you spreading the word, and what sort of folks are you reaching out to?
Absolutely. It's spread through communal communication. The numbers are published in certain community-based publications, advertisements, other community resources. The city and county EMS services are familiar with and ask us to take calls that they can't address. Maybe there could be a better effort at trying to make more people aware of it, but we have a pretty defined geographic area. They're not taking calls on the east side of town or in Brooklyn or in Overly in the county. So that I don't know if that addresses your question, but it's not a secret code. It is advertised, it is out and about, and it is published.
And if I may add, just very quickly, it's also based upon where people volunteer. So it has to be, the idea of it is that we can respond fairly quickly. So it's where volunteers are. So if volunteers are in one, like I remember when it first started, it was in a smaller geographic area. Now they're getting volunteers from Owings Mills, from different places. So it's kind of based off where volunteers are. Now, I do know from other ones throughout the state that I've heard about, it's kind of also like that, because remember, these aren't paid people. It's just, we want to volunteer, we want to go through the EMS and get all the training and become EMTs and get that training. So it's kind of based off where they are, because they leave their homes. It's not like they're in a hospital or a fire station waiting.
I was curious about how you got to the geographic boundaries that you serve. Is the location of volunteers the only factor?
That's because that's where our volunteers are. That's
Oh,
where
I know, I get what you're saying.
That's where they live and work.
That's right. So is the location of where the core of your volunteers live and work, is that the only factor that determines where you'll go?
I believe so.
Okay, thank you. I appreciate it.
And I should say, I mean, this is 24/7. I mean, people are getting up in the middle of the night to go to Senator Attar's house and help her son.
Let's hope not, that's not necessary, but I appreciate learning more. Thank you. Thank you, Mr. Chair.
Thank you. Senator Folden.
Thank you, Mr. Chair. So just have a couple questions. So the law already provides for what you're asking for volunteer fire companies and the like, ambulance rescue companies, correct?
Yes.
Okay. So if someone is in duress and they call 911, this isn't going to be a service or an opportunity or?
It may be. So if you're calling 911 in Baltimore City, they share radios like was just said, and sometimes Baltimore City asks them to respond if they can't respond. So it depends. Sometimes yes, sometimes no.
Okay, so
Yeah.
when they respond then, are they responding in vehicles that are owned by the said
They're privately
volunteer
owned
company
vehicles.
or their POV?
They're their
POV.
own vehicles, yes.
Okay. And as they are their own POV, are they required to notify their insurance that they are then operating a motor vehicle that may come into the issues of vehicle law?
I'll let counsel answer that. Do you know the answer to that?
I don't know the answer to that, but I would.
Because you're changing how a vehicle's being used for these type of services, and if they run a stop sign and hit somebody because they feel they're an emergency vehicle, the liability obviously is there, but is that liability shared with your company or the company, the volunteer organization?
I would say the organization does carry insurance,
Yeah, but you carry insurance, a lot of it for liability for actions taken. But if they're driving their own POV, I've seen a lot of organizations be like, hey, we didn't do that. You shouldn't have done that.
Right, well, I would point out, first of all, that while it is perhaps a change of use or a different use, it's not a commercial use, it's not Uber, it's not Lyft, it's not that.
I understand that, but you get people that get an excited frenzy when they turn on lights. And they go blink, blink, flash, flash.
Right, thankfully, we have not, I'm sorry.
No, I just wanted to say, you do bring up a good point. I do believe there are people who can answer that. Would it be okay if I follow up with you with that?
Yes, please.
Okay.
And then I guess the other component of this is, are they being trained as EVOC operators in that vehicle?
The answer to that would be yes.
And
And they're
where are they
being monitored.
where are they receiving EVOC training? EVOC, emergency vehicle operations.
Yes.
Of course.
The organization provides it as part of the ambulance training. So you have to be able to, first you have to be licensed to drive an ambulance. And then you have to,
Sure.
Then you have to be authorized to drive the vehicle itself.
So you're giving them additional training in their personal vehicle as an emergency vehicle operator?
It crosses over. If you're allowed to drive an ambulance, then you're allowed to drive a personal vehicle as well. So it's the same training.
Okay. And then, again, the last thing I have is that I'd like to see where you have calls for service with these documented issues of a 45-minute delay. Because if I'm understanding this, you're asking for lighting to be permissible, not siren, but lighting only, right?
Yes.
So does that mean if they start using their horn to get through traffic, which is that an authorized use or an unauthorized use of an audible signal? Because that's actually a component of traffic law.
Right, so.
So
The way that it's written is that it would, if it's not a harsh tone, then it's authorized, right? If it's not a wail or not a harsh tone, regular porn, traffic law does allow for it. But the purpose there is
to move vehicles, it does?
I mean, vehicles may not necessarily move out without a siren, right?
Yeah.
But we're not talking about, flipping on the wrong side of traffic and going 90 miles an hour down the street. We're talking about doing this responsibly. Also, every vehicle, there's only talking about five vehicles, right? So senior officers. Every vehicle that is currently authorized and currently implemented has tracking and technology in it to ensure that people are not misusing it in such a way.
So you're monitoring people's POVs?
Yes, yeah. So there's a button on their dash that when the tracking is disabled, the lights don't work. When they hit the button, GPS kicks on, it starts monitoring their lights, and then allows them to use it. There's also the use of the lights are specific to priority one calls, right? A situation like Senator Tyre spoke about, someone who can't breathe, obviously, we're going to get there as fast as we can. But when we're talking about a situation where someone calls and says, hey, I broke my leg, they'll wait the 3 minutes until we get there. We're not going to go crazy through traffic to help them with a broken leg. So there's
Well, we can agree to disagree on that part, because I've seen even fire rescue volunteers drive pretty erratically.
I can comment on stuff we do, right?
So, okay. No, I appreciate it. Thank you for your answers. Thank you,
Thank you. And I just want to,
Senator.
I just want to point out and stress that they've been doing this already for 5 years and there hasn't been any issues. But
Thank you.
I appreciate the questions.
Thank you.
Thank you. Just to piggyback a little off of Senator Henson, part of my district is the southern portion of Pikesville, and I wasn't aware of this. So certainly after testimony, I would love to have some additional information about the service.
Absolutely, and if I can just mention, I think Mr. Traub had mentioned earlier that Baltimore City, they have a great partnership. They've been working there for a long time. Baltimore County, it hasn't been as much, so that could be why, but absolutely, I'd love to have those further conversations.
Great. So to you're an attorney, the gentleman. Yes. How does an organization obtain the authorization as a nonprofit voluntary emergency medical organization to do this? And I'm assuming, is it Hatsila? Is this the sole organization that's doing this now? Are there others?
It's the only one I can talk.
All right, let's talk about
semi-intelligently about.
How does it have some sort of an agreement with the city,
Well, it is, it's licensed and approved and overseen by MIMS. It's works in conjunction with, as I said, and as the senator said, with both Baltimore City and Baltimore County.
Baltimore City and Baltimore County what?
Fire and rescue,
Okay,
EMS.
thank you. The other question I had, and I can speak to the senator. There was a letter of information from the Maryland Department of Transportation. Did you have a chance to look at that?
Yes, I have, and they're actually here, and they advised me that I can clarify that we've discussed it. It does say, and I don't know if I mentioned it, but I know it was at some point, it's 5 vehicles that can, that has authorization, and we've discussed it and everything since the letter was written.
5 vehicles, not 5 organizations, and, I mean.
Every organization can have their own, so like Hatala, they can have the 5 vehicles. It's every nonprofit, commercial company.
Appreciate it, thank you.
Yes, thank you.
All right, further questions from the committee? All right, seeing none, thank you very much.
Thank you, Mr. Chair.
So that'll conclude the hearing for Senate Bill 1030. We'll now move on to Senate Bill 1031.
Thank you, Mr. Chair, Mr. Vice Chair, and members. Dahlia Attar here on behalf of Senate Bill 1031. I said Dahlia. Mr. Chair, I do have the family of Nikayla Straughter here. If you can please stand up. The bill is named after her, and this is another bill that I'm before you that stems from a tragedy and multiple tragedies, unfortunately. A couple of years ago, we had a young child, Miss Straughter, and she was on her porch playing, and a 9-year-old came, had a gun, was playing with it. It was discharged, and it killed her. The gun belonged to his grandmother, I believe, and she had left it in a shoebox in her closet somewhere where this 9-year-old had access. A couple months ago in my district, a 9-year-old got access to her grandmother's, a gun that her grandmother left out, and that 9-year-old is no longer with us as well. We have a problem, and it's a problem when people have guns, whether they're legally, they have them legally or illegally. It's another problem if they have it illegally, but when they have guns and they are not properly securing them. Currently, under the law, if a gun is not properly secured, there are a few exceptions listed in it, but if it's not properly secured and a minor has access, there's only a fine. When prosecutors go and try to prosecute the grandmothers and the people that are leaving their guns in access of children unsecured, they have a very difficult time because there isn't much that they can charge these individuals with. So as you can see in the written testimony from the state's attorney's office, this bill was brought to me from state's attorney Ivan Bates, and he brought this concern to my attention. And their testimony talks about how when trying to prosecute these situations, they can either give a fine, charge them with what ends up being a fine, or they can charge reckless endangerment, which, as you can see in the testimony, the prosecutor who prosecuted that one is actually in this room today to answer any questions. But they have an uphill battle with that, and it's very hard to get through a motion for judgment of acquittal when that's the charge you're charging for something like this. So what this bill does is it adds a penalty. It says not just a fine, but you can get up to 5 years in jail if you are leaving a gun unsecured. We want this bill because we want to prevent future tragedies. We want there to not be any situations and no other families that have to be like the Straughter family. We don't want any other family to have to go through this. So I'm therefore standing before you and asking for a favorable report on this bill that adds a 5-year penalty to those who leave their guns unattended and with access by a minor. Thank you.
I'm so sorry to hear about this tragedy. And I had a lot of guns in my house with my children growing up, but we're fortunate that they were secured somewhere. I'm not sure perfectly, but secured well enough. So this is what I'm trying to understand. I can understand the frustration of this family, and that a penalty, it just doesn't seem to cut it. In addition, it may not curb behavior. So here's where I'm struggling. So I'm not against this bill, theoretically, and I see it's up to, not exceeding 5 years, and obviously the state's attorney of Baltimore carries a lot of weight with me anyway, in what he thinks, because he's doing a lot of good work. The question is, just like with speed cameras, you want to change behavior more than, I hope, you want to collect the revenue, right? You want to change behavior more than you want to put grandmothers or anybody else in jail, right? Or family members or whatever. So what data, what do we have that would show and tell us that increasing this from a penalty to a penalty and/or up to 5 years, that will change behavior versus more education, more training? You know, I hate to say this, and I don't know if this has anything to do with people getting older, because it may not, but, you know, for drivers, sometimes they ask people over a certain age to come in and beef up their skills a little more frequently once they get past a certain age. I guess I'm looking for what do we know would support the idea that this will change behavior, which is what we most want.
So that's a great question, and I'm going to begin, and then if it's okay if Ms. Brady comes up to see if she wants to add to it. But there's not one solution first. So yes, education is necessary. There is a lot necessary, training, providing resources for people to have the opportunity to have locks for their guns, making sure they understand leaving it in a shoebox in your closet where a child has access is not sufficient. So that's all necessary. What I can say is there's two parts to it. Number one, there's also the side of consequences. If a 15-year-old or a 9-year-old is killed because you negligently left your gun out, there also needs to be the consequences. But the goal is also to deter. And I can tell you, me speaking as someone who does have one at home in a safe, I think about it, and if I know that if someone gets this and something happens, I can not only get a fine, because a fine I could live with, but I could also go to jail for up to 5 years. At least me, that would affect me. I would say, I need to think twice about this. And I'm hoping there are other people who would think twice about it as well. Sometimes we have laws on the books as a deterrence, and sometimes it's for consequences. I believe that this is for both. And I'll see if Ms. Brady wants to add anything.
Because I'm with you, it would change my behavior, but I didn't even need the 5 years. I don't want anybody in my family to die, and I don't want any of my children to accidentally kill anybody or harm anybody, including themselves.
Understood.
So I'm trying to figure out, I'm all for figuring this out, but I'm struggling with this case that you know, the one we know about when Senator Carter was there, was just all over the news. How could you live anywhere and not know this case in Maryland? And yet, it's just repeated itself. So that didn't change behavior.
Yeah.
So I'm struggling to see how, I want to do something that will change behavior.
I appreciate that. And I do want to point out that the 5 years is kind of an arbitrary number, and if this committee decides that something else is
And I
better, that would
appreciate you
have
for
the same
bringing
end
it.
result, please.
Yep.
Do you have anything to add?
Thank you. I was looking at some of the written testimony, and I know Mr. Jocelyn, he essentially says that Ms. Gaskins was prosecuted, faced 5 years in prison for reckless endangerment and firearm access by a minor. And I believe the prosecutor, Ms. Brady, kind of, in her testimony, she speaks to the statute that was used. So I guess I'm trying to understand if you have a statute, because this would strike me as some sort of, reckless endangerment. The need for this additional, is this to pile on? Is that the prosecutor?
I'll let the prosecutor who prosecuted that case answer that.
Thank you.
Good afternoon, committee members, chairman, vice chair. Thank you for letting me speak today. I did prosecute Ms. Gaskins, and I did use the reckless endangerment statute. You'd be surprised to know that I had to do a lot of heavy legal research and lifting in order to take those charges against Ms. Gaskins. And that is because there was no precedent in Maryland for an action such as what happened here to be considered reckless endangerment. The problem with reckless endangerment is that it's not strict scrutiny, as this bill would be, right? reckless endangerment requires a knowledge on the part of the individual that their actions will cause substantial serious bodily injury or death. So that's a heavy lift when you're talking about a grandmother who obviously loved her grandson, but was a guardian and left a gun with one loaded in the chamber in the bottom of her closet in a shoebox. Did she know that that was substantially going to cause a death? It was a hard lift. Luckily, the judge that I was in front of, I passed MJOA, and he did find her guilty of reckless endangerment, but it was not an easy battle for me to win that. It was difficult. And in front of a different judge, and especially in front of a jury, I'm not thinking that that would have gone the same way. The way that the reckless endangerment statute is written, it's very difficult for a jury to follow the elements required for reckless endangerment and this specific act. If we pass this bill is strict liability. Somebody leaves a loaded gun in the access of a minor, they are guilty and face up to a 5-year penalty. You don't have that extra element of getting into someone's mind and trying to convince your fact finder of what that person was thinking. That's the difference. We aren't trying to add on. I think Ms. Gaskin's sentence was fair. It's not something that we're trying to throw the book at someone. We just want essentially what I'm hoping is done with this bill is that it also sends a message that this act, specifically of leaving a loaded firearm in access of a minor, that we take a stand on that and say that it is strict liability, that this is not okay. Especially with the proliferation of where carry transport permits in Maryland right now, we're seeing a lot of these cases of children getting access to loaded firearms, taking them to school. When something happens,
if I could
go ahead.
reclaim my time.
Of course.
When I had first heard that the Keller-Strotter Act was being reintroduced, and I looked at the fiscal note and said it hadn't been introduced in 3 years, which had me puzzled, because I know Senator Carter had introduced and reintroduced the bill a number of times. And now I'm saying this is the difference. This is a new bill.
This is slightly different. This would not require death, whereas Senator Cardin's bill actually required a death to occur. So unfortunately, it required a tragedy. This can address the issue before a terrible tragedy occurs.
Okay. Thank you.
Of course.
Excellent. Well, thank you very much. So for the Strotter family, thank you for, I know we engaged a lot in the last couple of years. I just want to say thank you for continued engagement, and obviously we all are hold you close, so thank you for being here again, and it's good to see you all.
Thank you so much.
Further questions from the committee? All right, with that, that'll conclude the hearing for Senate Bill 131. We'll now move on to Senate Bill 992. Is that Senator West?
Yep.
992?
Thank you, Mr. Chair. It's interesting. I think I presented the first bill of the session on the second day, and this appears to be the last scheduled bill of the session, so I'm both opening and closing things here. I brought Bill Carlson with me to answer questions. Could I ask him to come and have a seat? So if there are any questions, he can answer them. Thanks for the opportunity to present Senate Bill 992. This is the annual bill making technical corrections to Maryland's corporate laws. This bill is brought to us each year by the Business Law Section of the Maryland State Bar Association. The Business Law Section's Executive Council is comprised of many of the state's most prominent business and corporate lawyers. In the spirit of full disclosure, prior to being elected to the General Assembly in 2014, I'd been a member of the Executive Council for many years. Bill Carlson is with us once again to answer any questions about the bill. Bill is a longtime leader of the Business Law Section. This year's Senate Bill 992 focuses on the portion of the state's corporate laws that deals with what the stockholders of a corporation must explicitly approve in order for the corporation to proceed forward with the transaction. In this area of the Corporations and Associations article, there are various provisions holding that unless the corporate charter or bylaws provide to the contrary, the corporation does not have to secure stockholder approval to take certain actions. Senate Bill 992 merely adds another instance in which, unless the charter or bylaws provide to the contrary, stockholder approval need not be secured before the corporation does something. The something in this case is to transfer assets of the corporation that previously had been pledged as collateral for a loan and are the subject of a mortgage, pledge, or security interest. Senate Bill 992 provides that if the secured party exercises its rights under the mortgage or deed of trust or the grant of a security interest to take possession of and sell corporate assets, stockholder consent is not necessary. Alternatively, if the board of directors of the corporation authorizes the sale of the assets with the holder of the mortgage or security interest that results in the reduction or elimination of the obligations secured by the assets, and for which the assets are worth less than or equal to the amount of the obligations being discharged, once again, stockholder approval is not necessary. Section 992, Senate Bill 992 goes on to say that even if there is an ultimate determination that value of the assets was greater than the amount of the discharged obligations, so long as the person receiving the assets acted in good faith and provided value for the assets, the sale cannot be invalidated. There is another distinct component of Senate Bill 992. It provides that in the case of mergers, the document known as the Articles of Merger need not include ownership information about any partnership or limited partnership or limited liability company that's one of the parties to the Articles of Merger. This is because it's simply not necessary. It's extra information which is not helpful in the situation. So with this brief explanation, I'm pleased to recommend that the Judicial Proceedings Committee report this bill favorably, and Bill and I will look forward to answering any questions you might have about the bill. And let's have at it with the questions.
How is this bill applicable to non-stock corporations?
Excuse me?
How is this bill applicable to non-stock corporations?
One more.
Hi, Senator Sidner. This bill does not impact non-stock corporations at all. The Articles of Merger section speaks of exchanging equity interest, which a non-stock corporation would not have, and it speaks about what happens in the sense of a foreclosure if there are stockholders, and when you do and don't have to get stockholder approval, which in a non-stock corporation there are no stockholders. So it doesn't impact non-stock companies.
All right. And just for clarification, on page 4, lines 25 through the next page, I think Senator West, you had mentioned something about limited partnerships. Is the deletion of that section what you were referencing in your testimony?
Yes. So the Articles of Merger section requires there to be an explanation in the Articles of Merger. So if you were a party to it, you could read it and say, okay, I have so many shares of stock. What LLC interest do I get, or vice versa? And so you're required to express that. And that will stay. There's an additional requirement, which really makes no sense. It says when you're talking about LLCs or partnerships, you have to have that discussion in terms of percentages, which with some partnerships and some LLCs makes no sense. So you're required to give additional detail that sometimes is a non sequitur. It's meaningless. And so people sit there and try to draft Articles of Merger and go, well, how do I do this? Because I can't talk that way. There aren't percentages. So we're taking out an extraneous, superfluous section would be the recommendation.
Thank you.
While Bill's here, I forgot to mention, the drafting crew in legislative services made a little error, and we've had an amendment prepared. Bill, maybe you could refer to that.
Right, and what we had recommended so in the event a board of directors, for anything, takes an act that would be not in good faith, not in the best interest of the corporation, directors can be sued. That's the risk of being a director. And the manner in which this was written, we wanted to make sure that if someone thought, if a stockholder thought a director had acted inappropriately, you could still sue the director. And the manner in which it was written, instead of clarifying that, it actually limited the ability to sue directors. I'm not into like trying to sue directors all the time, but if that's a risk, that's a risk, and shouldn't be limited in this circumstance. So this clarifies that you can do either sue for monetary damages or have an equitable claim, either one, not just monetary damages.
And with that, we leave the bill in your capable hands. Thank you.
Thank you.
Further questions from the committee? Senator West, Mr. Carlson, thank you all very much. With that, that'll end the hearing for Senate Bill 992 and the hearings and the Senate hearings for the session. All right, yay. All right, we're going to take a 5-minute pause and then we're going to jump into voting. Our voting list number 7, which is the housing package, is the first on the docket. right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 11th, 2025. We are on voting list number 8. And we are going to start off with Senate Bill 608.
Senate Bill 608 makes numerous changes to the U non-immigrant status petition process as set forth in Maryland statute. So just to kind of back up and give some background on U visas, they are a type of non-immigrant visa which is available to individuals who are helpful to law enforcement in investigating, prosecuting cases, cases involving certain qualifying crimes. So essentially the way the process works is a person has to get a certification from typically a local law enforcement agency, occasionally a prosecutor's office, that essentially says that this person has been helpful in investigating or prosecuting this crime, and then that enables the person to federally apply for the U visa status with United States Citizenship and Immigration Services. So the bills essentially deal with the process in state law that governs certifying entities here in Maryland. Specifically, it includes an attorney, victim advocate, or other representative of the victim as an individual who may request certification. It establishes that there's no statute of limitations for when a qualifying criminal crime had to occur. And it requires, if applicable, a certifying official to provide a written explanation to the victim that sets forth why they denied a certification. So there is an amendment in your packet, which is number 173128/1. Among other things, this bill takes provisions that were part of a different bill, Senate Bill 553, which also deals with the U visa process. And with some changes, it moves them into Senate Bill 608 and also makes some changes to Senate Bill 608. So specifically, Senate Bill 553 created a rebuttable presumption that if a person had not unreasonably refused to provide assistance to law enforcement, that they would qualify for the certification. It altered some of the timeframes within which certifying entities were required to make a decision on a certification. And it required certifying entities to have protocols to assist applicants who might not speak English. And getting into some of the changes that the amendment is actually making, it changes some of the language to more closely align with federal guidelines that are provided for states to deal with U visa certifications. It alters those timeframes that are in Senate Bill 553 for when a decision has to be made. So specifically, the general rule would be that a certifying entity has to make a decision within 30 days. However, if the individual or the victim, the applicant, is in deportation proceedings, that would go down to 14 days. If the individual is in deportation proceedings and is detained, that would go down to 7 days. And then there's an additional circumstance in which the time would go down to 7 days, which I think requires a little bit of explanation. So when you qualify federally for the U visa status, you gain protection, but also certain minor family members that you have would also gain protection as part of the U visa. However, they have to be minors at the time you are federally approved for the U visa. So what happens sometimes is someone might be a minor at the time the application is made or even when the certification at the state level is received. But if they age out before they're federally approved, they would no longer be covered by the U visa protections. So one of the things the bill is doing is saying that in those circumstances in which a minor family member who would qualify for protection is essentially on the verge of aging out of that protection, then the certifying entity would also have to make that determination within 7 days. And then finally, the last change being made by the amendment is to reframe that language, which I described as a statute of limitations. So rather than saying there's no statute of limitations for a U visa application, it would say that a certification may not be denied solely on the basis of how long had passed since the qualifying crime occurred.
Thank you, Mr. Chair. So, Counsel, I just want to ask, because you brought up about, and maybe I missed it, I'm going to apologize if I did, but that you were trying to bring, that some of these amendments bring it in compliance or in line with more federal provisions are currently established federal guidelines, is that correct?
Yeah, and specifically, if you want to take a look at the language,
Yeah.
it's several times on page 3 where the phrase "including sentencing" is being stricken, and it would now read, in the detection, investigation, prosecution, conviction, or sentencing of a qualifying criminal activity. That's the exact language that's in the federal guidelines.
So it strikes out the including sentencing?
Yeah, it's just kind of rephrasing so that
Okay,
it matches
and then-
exactly the
Okay,
federal.
so thank you for that. And then the next question I have is, does the federal guidelines, because I see that we've added in, originally it was an agency under page 2, line 5, talks about an agency that has criminal jurisdiction or, investigative detention jurisdiction relative to the agency's area of expertise. That included child protective services. However, what I see now is that we've added in civil, family, or administrative detection, investigative, or prosecutorial jurisdiction, including adult protective services. So how is that in relation to any of the federal?
I believe, and I'd have to double check, but I believe that also is matching, and it's to account for the fact that a number of agencies that are not typically law enforcement agencies actually have the ability to certify a U visa application.
Okay, because that's what I was looking at, because I know that, I think one of the examples brought up was relative to a domestic dispute. But that kind of would fall under both in a way. So if there was an assault, that would be a criminal act. But if there was just a, not to minimize it, but if there was just a domestic violence incident with no assault, the way I'm reading this, then because that falls under potentially, if there's a dispute over civil or family property, even if they're here not legally, that they would be eligible for the U visa?
So there does need to be a qualifying crime, and I think the language that you're pointing out is essentially reflecting the fact that it's not necessarily just the law enforcement agency who could do the certification, but you don't qualify, I think, for the U
Josh, I'm
visa.
sorry, I didn't hear you.
I'm sorry,
That's okay.
I apologize.
So there does need to be a qualifying crime, and qualifying crime is federally defined. So the language you're pointing at, which is kind of expanding the ambit of the agencies involved,
Yes.
is to reflect the fact that those types of agencies can do the U visa certification, but they do need to certify that you were helpful in one of those stages of the criminal process.
So the part where it talks about the certifying official is relative to the part where we're just talking about the different entities and types, correct?
Correct.
Okay. Okay, thank you.
Further questions from the committee? All right, I'm going to move that we adopt the amendment so we can work off of the bill as amended. So motion it's been seconded. Is everyone okay adopting the amendment before you? Okay. Now the bill's before you as amended. Further questions and/or discussion? It is a very good policy because it will encourage people to participate in helping solve crimes and interacting with investigations and solving crime in law enforcement. So without the, yeah. So there's been a, I'm sorry. Sure, take your time. No, sure. Well, so. Okay, so the bill is amended. We're going to hold it to the end of this calendar. So we're going to go on to, I want to make sure that you have an opportunity to participate in the next debate, so I don't want to detract from that, but, okay. All right, so then that means that we'll go on to Senate, maybe let's go ahead and explain 977 and potential headings. One second.
And then you prompt me to do that.
All right, go ahead, for Josh.
So Senate Bill 977 prohibits a law enforcement agency and a unit of state or local government from entering into an MOU or similar agreement that requires collaboration or information sharing with a federal agency for the purpose of enforcing federal immigration law. It also alters certain requirements and restrictions relating to access to information on databases operated by state and local law enforcement agencies, as well as databases operated by state or local governments. It also has certain provisions relating to state agencies allowing access to facilities to individuals seeking to enforce federal immigration law.
So I think it was, maybe was it last term or was it
2021.
2021? We passed the bill protecting the MVA database from immigration enforcement purposes, requiring a judicial warrant. But that bill also was a little bit more expansive and included most of the data that you require to get like PIA and MPIA request for. So it required a judicial warrant for all of that information. So my question to council is, it seems as though we may have covered this turf in 2021 when we passed that initial bill that protects our state information from our state agencies from being released for the purposes of federal immigration without a judicial warrant. But if you could just give us some more clarity on that.
Yeah, so that bill in 2021, which is now part of General Provisions Article Section 4-320.1, did require all state agencies to deny access to any portion of a record with personal information to an individual seeking to access the record for the purposes of immigration enforcement, unless that person presented a valid warrant. So essentially, anything that would be subject to PIA is already has that restriction on access to it.
So then in the hearing, so it looks like we may have covered that. So, we're doing more research, but it looks like that's covered. We covered it in 2021. But well, good question. So then the next part is just like for data brokers, or is that those third-party consumers of information that get state information and then maybe sell it to third parties or to a government agency for immigration purposes. Does this bill cover that in any form or fashion?
Not with the way it's currently drafted. It applies to the state agencies themselves.
So we may want to look into that piece of it since the first part may be covered. So we've been in discussions for the last week of how to best to address this. So we may hold this bill for, a day or two to figure out where some of the gaps are and what we can do. So hold it. Senator McKay.
In 2021, Council, what was that bill number by chance? I can get it later, that's fine, but.
It was my bill.
So it was actually, can't recall, let me see, I have the chapter number was chapter 18 of the special session, but the, let me see.
It was in the
I'll pull-
special session, because that was,
The bill number was, no, that's not correct. 2021 special session. It was House Bill 23 and Senate Bill was Senate Bill 234.
thank you.
All right, so we'll now move on to, Senator Fulton, are you good, or are you still looking at stuff?
I'm just actually waiting on the call back.
Cool. All right, we're going to go on to Senate Bill 828.
Senate Bill 828, as drafted, requires the Attorney General, in consultation with appropriate stakeholders, to develop guidelines for entities operating at sensitive locations that limit immigration enforcement at those locations to the fullest extent possible with federal and state law. The bill then requires certain state entities to develop and adopt policies that are consistent with that guideline. There is an amendment in your packet, which is number 153324/1. The bill does several things. First of all, it adds a general requirement that a unit of state government operating at a sensitive location shall deny access to any portion of that sensitive location that is not accessible to the general public to any individual who is seeking access for the purpose of enforcing federal immigration law, unless the individual presents a valid judicial warrant or there are exigent circumstances. The amendment also alters the definition of sensitive location, which is now found on the unnumbered lines after line 11 on page 3 of the reprint. It continues to require that the Attorney General has to develop and publish guidelines regarding immigration enforcement at sensitive locations. It adds some language to what's required in the guidance to cover the responsibilities and restrictions, the responsibilities and rights of individuals who interact with federal law enforcement personnel. State agencies are now required to adopt on or before October 1, 2025. Each state agency that operates at a sensitive location is required to implement a policy consistent with the guidance. Also added to the bill is a provision which clarifies that the guidelines developed by the Attorney General and the policies developed by the state agencies are not subject to the Administrative Procedures Act, so things like notice and comment. And then finally, on the last page of the reprint, the amendment changes the bill from being an emergency bill to taking effect on June 1st.
So based on the amendment, I've got a bunch of questions. The bill only governs a unit of state government that operates at a sensitive location. So I'm looking at the sensitive locations. Public school the schools typically are governed by the counties, are run by the counties. Would that be a unit of state government? The county that runs the public school?
It would not.
Excuse me?
It would not.
It would not. So if ICE wanted to come into, in my district, the Delaney High School, there's no unit of state government there, so that would not be a sensitive location under this bill.
It would not be covered by the warrant requirement or the guidelines. It would not have to adopt policies because it's not a unit of state government.
Okay. And public libraries, my understanding is they're typically run by counties or municipalities, not by the state. So the same thing would be true for them.
If they were operated by local government, yes.
Healthcare facilities, this specifically says operated by a unit of state government. What are we talking about? Are there state, I mean, like Spring Grove or something like that?
Yeah.
Spring Grove would be covered, but Johns Hopkins Hospital would not. University of Maryland Hospital might be covered?
I think they would be, yes, because they're private.
Private's not covered.
Private's not covered. A shelter. Most shelters, I think, are run by counties or municipalities. Does the state operate any shelters?
I do not know the answer to that.
But there's a bifurcation. If they did, then the policies would apply. If they don't, then the guidance would have to be there. The guidance would be applicable.
Right, so this bill has really been narrowed in its scope from the way I originally saw it.
Yeah.
Is any other location that provides state-funded services relating to physical or mental health or education, what would that encompass?
So, and I should note on that point, those would be considered sensitive locations to which the guidance would be offering, would apply. However, if that entity, if that space is not operated by a state agency, they would not be subject to the requirement to adopt policies. So that the guidance would be speaking to them, but they would not have that second requirement to adopt a policy because they are not a state agency.
Say that again. So let's assume that Delaney High School, the Baltimore County Public School System receives state money. Some of that goes to pay for Delaney High School. So we ascertained earlier that Delaney High School probably would not be subject to this because there's no state agency operating there. but because they receive state money, how would this bill apply to them?
So the guidance that the Attorney General promulgates would essentially speak to them.
They would receive a copy?
Yeah, the Attorney General would be required to kind of consider them because they are within the definition of sensitive location.
Yeah.
But because they are not a state agency, that second requirement to adopt a policy would not apply to them.
And what kind of guidance would they get that would not result in a policy?
Yeah, I think it would be something to the effect of, these are the laws. And, I mean, that's really more a question for the AG when they develop this, but it would probably be in the form of sort of legal advice. Hey, here's what the law is, here's how we interpret that.
Okay, thanks for the explanation.
Senator Henson.
Chairman, trying to flesh out the portion for provide state-funded services, would that extend to grant-funded programs?
But if they're not stated.
Yes, for the.
Yes, so essentially they would be considered covered by the definition of sensitive location. So the AG would kind of, the guidance required for the AG would be speaking to them. But if the entity is not a state agency, they would not have that second step of being required to adopt a policy.
Okay. And then for the guidance, is there any sort of duty that's created by that? If the AG's office has a guidance that says you should follow X, Y, and Z, and then a state-funded organization that provides physical or mental health does not do that, is there any enforcement of that?
No.
Okay. And then, sorry, go right ahead, Mr. Chair.
The state agency, it's only policy specifically carved out from like regulation. So it's policy, not regs.
Okay. And then we had our comptroller here testifying about her desire to make sure that as people engage her services, that they would be safe in doing so. So she is a unit of state government, the comptroller's office is a unit of state government, but I don't see them kind of falling within the definition of sensitive location. So if a person goes to the comptroller's office to engage their services, would her office not be covered under the bill?
Under the bill, every non-public area of her office or of that government agency would be covered.
So, and I should clarify, that piece about the warrant is kind of, it's a separate
piece.
It doesn't really work with the other pieces, so that would apply.
To every state government, regardless of if it's a sensitive location?
No, not the way it's drafted.
For the warrant piece, if you're going to go in a non-public place.
Okay. Thank you, Mr. Chairman.
Thank you, Mr. Chair. Going back to Senator West's comment, a question, if we could flesh that out a little bit more. Counsel, when you said that the Attorney General would provide guidance and that guidance would be, this is the law, what would that mean for the public school? What does that mean? This is the law. What is the law regarding whether immigration can come into that public school and detain someone?
I think that's a complicated and somewhat unsettled question. I don't honestly have a good answer for that. I think there are a lot of arguments going on about it now, which I think is one of the reasons why there was some desire to have the Attorney General weigh in on it.
Got it. Thank you.
The answer is the Attorney General's.
I just wanted to understand how police stations are handled, because we carve out correctional facilities, but my understanding is that police stations have like holding facilities. I imagine there might be a handover at a holding cell or a police station, so I just wanted to understand
Local correctional.
how,
Yeah, let me.
if a police station counts as a local correctional facility, or we need to carve that out in addition to our local correction
Pull up
facilities.
a definition of that.
In a police station?
So
assume so, but
what he's alluding to is that, so like the 287G programs, like this is also in 2021 or 2020, I think we passed the same year, but we curtailed the state's ability to engage in 287G programs for field enforcement activities, but for the detention centers, that was left untouched. And so that's the question you're kind of squinting towards. Sure.
You worried about? So I think there are a couple potential solutions to that. I mean, one is if they can, have the pickup occur in an area that is accessible to the public. That would be one way to get around it. I mean,
Yeah. All right, Senator James.
I just want to make sure I understand what's happening up there. So without putting anybody on the spot, but I just, so when you're ready, just let me know what just happened in the sense of what's going on with police stations with holding cells, because I have a couple in my county, and they're in my jurisdiction, in my district. So I just want to understand what we think is going on.
Why don't you read the definition of a local correctional facility?
yeah, a correctional facility means a facility that is operated for the purpose of detaining or confining adults who are charged with or found guilty of a crime. And then a local facility is a correctional facility operated by a county or municipal corporation. So I think the question is, would this facility, is it operated for the purpose of detaining individuals?
In practical speak is that, let's say somebody in Havre de Grace jurisdiction is arrested and may well be held there, charged with a crime, and may sit there for a little while before they have a hearing or determination of the charge for them, and that happens quite often. Now, I think you're right, though, that once adjudicated, if they're found guilty, unless there's a capacity issue at our at our detention center, they would then probably be moved to the detention center. But that's not always ironclad. If it's I'm just thinking of something really minor like disorderly conduct, somebody was inebriated and maybe they get 5 days, it might be held in Havre de Grace. But if it's anything else, it would go up to the, our detention center. So I get that this is gray, but with that in mind, does that help you at all answer the question of whether or not, in some circumstances, Havre de Grace's jail facility, we call it a jail, it was holding cells, might come under the current language? Does that?
Within a police station.
Within that police station. Or if not, maybe we could just figure that out just for clarification at some point before we vote. Thank you.
All right, we're going to hold this bill, and we're going to move back on to Senate. Phil, are you okay? You still need help? More time?
Just still waiting to hear back. The only thing I'm checking on is I want to make sure that what's obviously been stated here regarding federal UDISA guidelines, and we're talking about being some.
All right, so here's what we're going to do. No, what we're going to do is we're going to go, so Senate Bill 977, obviously we're going to figure out with the data brokers what we can do with that. And then Senate Bill 828, it seems to be a lot of questions, so we are going to workshop that a little bit further and get that in good condition so that we can answer everyone's questions. Senate Bill 608 is just pending one last question. I think there's readiness to move on that, but I'd like to move all three of these bills together if possible. So we'll continue work on them and we'll move them shortly. So now, are we ready for housing? All right. Let's go on to voting list number 7. Yeah, John's coming. He's coming. We're going to start off with Senate Bill 46.
Procedures under which a sheriff's office must remove a person who is allegedly in violation of the bill and return possession of the property to the owner. The amendment that you have in your packet strikes out that entire bill and instead replaces it with the wrongful detainer process. And so I'm going to go by the amendment when I say page numbers because it's just the wrongful detainer process. So,
Okay, hold on, do we have that amendment?
yes, it should be on the top. Senate Bill 46.
Sorry. Yeah, got it. You're right.
Yeah, okay. So as I was saying, this creates an expedited wrongful detainer process. In subsection D, the new paragraph 3 requires that when they issue a summons, the summons does not have to contain the defendant's name and may be addressed to occupant located at, followed by the property's address. On the following page, it authorizes the posting of process on the properties for all instances of services, not just if they can't find the person. And then in the new paragraph 6, it requires a hearing for a wrongful detainer to happen between 4 and 7 calendar days after the complaint is filed. And now down in the new subsection F, the complainant has to provide sufficient evidence to the court to demonstrate the complainant's legal interest in the property. In subsection D, paragraph 1, Roman numeral 2, it adds in that when the court issues a warrant to the sheriff, commanding the sheriff to give the possession back to the complainant, they have to do so immediately. And then on to the next page. This is requiring, it removes the requirement that the court has to find the person in actual possession was personally served or there was service or submission to the jurisdiction. Or, yes. So you have in order to give them to the complainant damages, costs, and attorney's fees, all that is required is for the complainant to get those damages and costs is to claim it in the complaint. Down in the new subsection I, that adds that if the defendant does not attend a hearing, the court has to enter a default judgment against the defendant. And then down in what is now subsection J, it reduces the time period for appeal from 10 days post-entry of judgment to only 4 days. On to the next page down in paragraph 3, that is saying it reduces the time period for a hearing on appeal between 5 and 15 days to be between 4 and 7 days. And then right under that, in paragraph 4, it reduces the numbers of days before a hearing on appeal that a notice of the order for appeal must be given to the parties' counsels from 5 days to 4 days. And that's the end.
All right, Senator Henson.
Thank you. I just want to check for clarity. Does this change any of the service requirements for wrongful detainer? Not if you want personal service to get damages, but just the regular nail and mail service requirements for wrongful detainer?
I don't believe it. Hold on.
Some to a person.
I know that's in subsections
Yeah.
3, 4, 3, well, I guess they were old 3 and 4, and now they're new 4 and 5.
They can still do that.
Okay, I just wanted to check for clarity on that part.
Mhm.
And then for the wording of it says, in section G, little 2, that issue the warrant to the sheriff or constable demanding the sheriff or constable to immediately deliver possession. And then it also has a 4-day appeal period where you can appeal within 4 days. How does the 4-day appeal window and the immediate possession, how do those work together?
I would, if they have to immediately,
When does the 4-day clock start?
oh, the 4-day clock is after the entry of the judgment. So they could, I guess, theoretically.
So
do
it
before the
sounds
appeal.
like, and correct me if I'm misinterpreting, it sounds like the goal is to shorten that appeal period from 10 days to 4 days, but the goal is not necessarily to get rid of the provision where you stay execution of it until the appeal period is over. Because right now, you got 10 days, so you can't move on it. You could submit your request for a writ in the normal course, but the judge won't sign it until that 10-day appeal period has expired. So is it our goal to totally change that and to allow you to get your writ signed before that? Or is our goal to kind of stay consistent with this?
Shrinking the process.
Just to shrink the time, but not necessarily get rid of the stay that happens in between.
That's right.
So I think the word immediately there might give us a little, a challenge with continuing to kind of hold the same procedural timeline, just shortening from 10 days to 4.
I mean, just immediately just applies to it.
Mm-hmm.
just tells them to do the expedite. It just doesn't change. I don't think.
No, because immediate.
Yeah, that is in conflict.
Yes, the 4 days is good, but you just want people to be able to appeal too. Yeah, in case it wasn't right.
But you're right, it's in conflict. Person.
Mm-hmm. When you read it, Mr. Chair, do you see the stay of eviction still happening during the appeal period? Or do you see immediately, meaning you walk out of the courtroom, you go down to the clerk's office and you can get your writ?
Latter, so the former, rather.
Okay.
Yeah, so that's why I don't really, if you want to take it out, I don't have heartburn. You know
I think
what I mean?
I think it would help for clarity. And I think the goal of still expediting the process so that folks who do find themselves with a legitimate squatter who's come in, who's taken possession of their property, our goal to get them relief sooner, I think we still accomplish it if we keep everything else, but if just the immediately part wasn't there, it does give that appeal period the time to operate.
Yeah, I don't have heartburn on that.
Okay.
I mean, yeah. Senator West.
On the last page of the reprint, it's new section J. I think what it says is the person who's actually in possession of the property, the squatter, can retain possession until the determination of the appeal. But in order to do that, the person must file a bond and also has to pay into the court the fair rental value of the property for this period of time. So
That's if they note an appeal.
What's that?
That's if they note an appeal.
If they note an appeal,
Yeah.
right.
That would stay. I'm talking about the 4-day period where you're trying to find a lawyer and figure out if you have an appealable issue. Like, you don't want them to just go and get a writ that same day and then you're tossed out that night. You do want people to be able to decide if they will file an appeal. So if they do file an appeal, I think that language we have works. If you want to keep possession, you post the bond. That way, if you're not successful, the landlord does have something to recover.
Right. So you're talking about the time between the judgment of the court and the filing of the appeal 4 days later.
That's right.
Yeah, but I don't care. It seems to me we should somehow provide that the squatter, the alleged squatter, is not dispossessed while he or she is deciding whether or not to appeal.
That's right. I agree with you, Chair.
Can you, I'm going to apologize, Senator, because I've been trying to do a couple things, but can you, when you were talking about immediately and then you were said about 4 days, can someone just
Where in the bill is it?
clarify that up for me? Because my understanding is the people that I've spoken to, their concern is that someone being allowed to stay there after like a ruling, and then they go back and they damage because they still have a legal standing for the 4 days or however long for the appeal, then they go back and damage the property to make its value greatly diminished. And that's something I know I want to try to avoid, that once there's a ruling, they still have an opportunity to appeal, but if there's a ruling like that the sheriff's office has them vacate immediately. Am I on something else here?
No, you're absolutely right. Allowing for 4 days for the appeal period, it would create that opportunity where if a person walked out of the courtroom and they were very angry and they wanted to destroy the place, they could.
Yeah.
But I think kind of the presumption in our laws is the innocent until proven guilty. It's the you are not dispossessed until you have at least gone beyond the period of appeal. So for us, in our judicial system, court date isn't the end. You still have your post-judgment rights. And under this one, you got that 4-day window to appeal. So I get your very real concern, but I think it's embedded in the way that we do law.
Yeah, and I understand that, but I also, like, if I liken it to someone that gets, a DUI, we take away their hard license right away. And so that provision, everybody's going to know that they interact with. My concern is, again, is that by allowing a 4-day window, that the damage could be done, and they already don't have a legal standing, because the impetus behind this is these people that are going to these residences and sitting there while they're vacant, and then they feel that they have some right of ownership, and the courts are saying, well, we're going to wait, even though they don't. They haven't been paying a mortgage, they haven't been paying rent, they haven't been paying anything. And so now we're giving another step or another protection that we give them 4 days to go back, get their stuff, when in actuality, you know, if it's shown that it's not their property and someone has the legal paperwork, yeah, they could still do their appeal. But at that moment, wouldn't we want to just say, that's your property, get them out? They can appeal, but get them out now so that they can't ruin and pull all the copper pipes out or pull all the, you know, damage all the drywall. The idea would be to have them vacate immediately to minimize any further encumbrances on the actual owner's financial right to the property.
Two things. One, you have civil remedies. So if a person does go and do that, you could sue them for civil damages.
Most of them are indigent, though. That's the
It
issue.
would make this very dissimilar from any other eviction process. If you lose on a failure to pay rent, you could go back to your apartment and tear it to pieces, and you still have your appellate rights that have to expire before your landlord can file a rent. So we would be changing this for wrongful detainers to be unlike anything else.
But the difference in that, when you have rent eviction, you have a renter who has a legal standing and use and possession of that property. Whereas this one is showing that there is no clear use and possession through ownership or rent or agreement. So there's a difference there. One has a legal contract. One is someone that goes in and squats on your property, and we're trying to make it to where they have to get out. They don't have a legal standing. One with the contract does. Even if they're behind, it spells out that they've got to vacate and you got to go through the eviction proceedings. I'm okay with that. This one is a very different beast in all itself, because there is no legal standing. There should be no legal standing, because they've literally assumed someone's property without their permission, without a contract, and without said payment for usage of that property, and should be vacated immediately.
I think the difference is when you see that determination as being made and when I see it as being made, or perhaps the way that the presumptions underpinning our law, you see that determination as judge says you are here wrongfully, bangs the gavel, and immediately they're wrongful. The law operates in a way that that's not finalized until their appellate rights expire. So after those 4 days expire, then whatever the judge said in the court is the law of the land and is the reality. But what we would be doing is you make the appeal null and void, because the appeal, you have to prove wrongful detainer. If I take away your possession before I even let you file an appeal, you've got no standing for an appeal, because you're not in possession of the property.
But and that's the point, is there is no legal standing to have possession of it as it is. So in a civil. So clarify, I mean, maybe I'm missing something as far as the immediacy, because that's one thing that
about having your like, for lack of a better term, your due process rights exhausted, and what the presumption is in terms of whether you are in lawful possession of that property or not, and letting the process play out to determine that.
But the process, a part of that process.
Yeah.
I understand.
I understand what you're saying as well. I mean, I get it.
So the process is that there is no legal right to the property as ruled at that moment. Now, if they want to appeal it and try to get back into it, my concern is for the property owners that don't want their property damaged further by someone that's already been in illegal possession of said property, by allowing them to go back and then damage everything. I mean, the owner is going to have to pay for somebody to come and move the stuff out regardless, for the sheriff's office to stand by for any proceeding. So.
Confirm this. My operating assumption is if a court holds that the squatter has no right to the property, and the squatter retains possession of the property for 4 days while deciding to appeal, and in the meantime destroys the property, a criminal case can be brought against that squatter. Then the court is held, he has no right to the property. Am I not right? Aren't there all sorts of counts that could be filed against that person?
Yeah.
So that would be a pretty good deterrent, I would think, to not trashing the property, because I wouldn't want to go to jail.
Senator McKay.
This may not be exactly the same, but dealing with the word immediate. Didn't we pass the red flag law that immediately the guns were taken away, but you got your due process in a couple days? Can you tell me what really the difference is? Why aren't that being violated compared to, so to me, we do have precedent that says the word immediate needs to stay.
I hear what Senator Folden has been saying, but I also want to say that there are also some others, people that we're not talking about, who may be in possession or wrongfully detaining the property, and that's people who were conned themselves. So I say that in thinking about that, I come down on the side of Senator Henson.
Thank you, Mr. Chair. I also agree with taking out immediately for two reasons. One, with respect to Senator Folden, you're prejudging that the appeal will uphold what the judge has decided, and we can't do that. And then two, I'm very concerned with what Senator Henson just said, which is if that person is immediately removed, then that person no longer has standing to appeal. So we have completely wiped out their appellate rights. So for those reasons, I would take out immediately.
All right, we'll check on that, but here's what I'd like to do. Let's adopt the whole amendment, and then we're gonna have a discussion on that word immediately, and then we can do a roll call on whatever the motion is, if there is a motion on that word. So I'd like to adopt the amendment. Is everyone okay adopting the amendment? Okay. Further to Senator James.
Inspire any confidence, but where's the word immediately in the okay. All right, well, that's this. Wait a minute, where are you? That's page 3 of 5. I'm looking at the read. Thank you for that. Let me see where this is. Where is this? I feel good now. Okay, thank you. Listen to this whole debate and trying to find this word. All right, the complainant shall provide sufficient evidence to the court.
What'd you say? You want to do immediately?
We want to do it immediately.
You want immediately?
Which actually means 4 days. I like this code.
That immediate's already in there, so there's no motion.
All right, so we,
Issue, it's, if the court
Thank you, Mr. Chair. I would move to strike the word immediately in subsection G, little number 2.
Seconded Senator Henson's motion. We're gonna do a roll call on that. Further discussion, go ahead, Senator Folden.
strike that, not add in any new language? Okay.
Okay.
Still 4 days.
Still 4 days.
So deliver, would we take it up?
Vice Chair Waldstreicher.
It's to strike it, so.
Yes, to remove it.
So I'm a no vote, and if it's okay, I'd like to explain my vote. I apologize for taking time, but I think that so the balance of the equities here is that I think the amendment, yes, the amendment is well intentioned, and the question is, do we have more victims in this situation who have been wronged, who are being brought to court when they have a right to be in the apartment, or do we have more people who unfortunately are taking advantage of the current situation? The testimony in the hearing seemed to be the latter, and so I think that weighs towards keeping immediate in, and that's why I'm voting that way.
Senator Sidnor.
Yes.
Senator West.
I'm going to vote no. Let me explain why. I disagree with Senator Love. The person who was held by the court not to have the right to possession does have some indicia and presumably presented it to the court, like a fake lease, a lease which the court held was fake, but it still is a lease bearing a signature. And I think that gives the person standing to file the appeal and proceed on the appeal. So that being the case, I'm voting no on this.
Senator Muse.
No, yes, and still have the 4 days.
Well, the 4 days will still be there no matter what.
Okay.
So still a yes.
Moves it up.
Yeah. Senator Folden.
No.
Senator James.
No, but if you remove immediately, the reason I'm saying no is that I think you just create more confusion, because without it, you all are assuming it's 4 days, but I don't read the statute that way. But anyway, the answer is no.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
Immediately nay.
Senator Charles.
I'm a no, and I'm going to explain my vote. I just can't imagine being somebody taking possession of your home and you trying to get it back, and you have to wait and wait and wait just to get back into your home. And so I am a no on this.
So the amendment fails. Okay. There's been a motion to move the bill's amendments. It's been seconded, but Senator Muse has.
I'm sorry, just a question, because whether we have the word immediately in there or not, it's still 4 days.
Still 4
right?
days.
So how does that help? In your situation, what does that do for a person who still has to wait 4 days, whether you vote yes or no? I just want to know if there's a difference, so I know if I.
Yeah, I'm hoping that person should be able to get back. And I know
they got 4 days.
I know Senator McKay brought up an issue about the red flag law. I don't know how do we make some level of amendment to replicate that.
Well, now this is more akin to that.
Oh, that's the difference. Okay.
This is more akin to that now.
Okay. The victim, even within that, they have 4 days to appeal, but until they appeal, the sheriff can still come in day one.
Yeah.
Whether the word immediately is there or not, it remains the same. We don't. Okay. Okay. Gotcha.
Okay. So there's been a motion. Favorable. It's been seconded with the amendment. Do we need a roll call, or is everyone okay being recorded in the affirmative? All right. Senator. Senator. All right. Hold on. All right. So we'll go back. Hold on. Senator Charles wants to be on as a sponsor. Senator James wants to be a sponsor. Senator Folden wants to be a sponsor. Senator West wants to be a sponsor. Senator McKay wants to be a sponsor. And Senator Henson is down on the bill. That was fun. Something like that. All right. We actually moved the bill today. That's great. All right. All right. Now we're going to. Other side of the ledger here, we'll do something, Senator Sidnor, Senate Bill 107. And then ready.
When you retire, give some of your pictures over to us.
Senate Bill 107 established that it is lawful for a person to intercept an oral communication if, 1, the person is working as a fair housing tester for a fair housing testing program operated by the federal government, the state, or local government, or a nonprofit civil rights organization. 2, the person is a party to the communication. And 3, the interception is being made for the purpose of obtaining evidence of a fair housing violation under federal, state, or local law. The content contents of an intercepted oral communication may be used only to enforce federal, state, or local fair housing laws. Otherwise, the contents of an intercepted communication and any evidence derived from them are inadmissible in any trial, hearing, or other proceeding in or before any court, grand jury, department, officer, agency, regulatory body, legislative committee, or other authority of the state or political subdivision of the state.
Nothing more than we passed this bill last year. I know we have a couple new members, and I know their feelings on this, but I fully expect that this bill should pass, and look forward to talking about it on the floor.
Vice Chair Waldstraker.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
107, yeah. No. To explain my vote, I just want to point out that we're creating a new two-party consent rule within the state. We don't protect victims of domestic violence to be able to record their assailants while they're happening. As a matter of fact, if they do, we are turning them into felons if they go to the state's attorney's office by recording such violent attacks. But we're going to create a new oral communications interception rule regarding fair housing. We're not protecting victims here, and I'm not saying that I'm talking about physical victims. It's another victim type crime, but this body continues to not move on those that are being seriously hurt every day, and because of that, I will say no.
Appreciate it. We don't have that issue before us this year yet, and look forward to having that discussion when it
We had a
happens.
hearing. We had a bill.
We have the House version now, but we don't have the Senate one yet.
Senator James.
Well, that was really a great explanation, Senator Bolden. Now I feel very badly. I'm very worried about the bill, and I really like the sponsor. I know what he's trying to do, but I'm sort of a little bit with Senator Folden on the issue of what this means going forward. So I'm going to pass until we finish voting, till we get around it, which I.
Senator Henson.
Yes.
Senator Love.
No, and I'd like to explain my vote. I appreciate the sponsor and what he's trying to do, and I think fair housing testing is very important, but I am concerned about opening up our law in this way, and especially in light of what Senator Folden said.
Senator McKay.
Nay.
Senator Charles.
Yes.
Senator James.
No. With all due respect to my good.
Chairman Smith.
Yes.
7-4.
All right. Senate Bill 107 passes. What about
120 is no opposition.
which one?
120 is no opposition. It has no amendments. We have
Senate Bill 120.
Senate Bill 120 alters statutory provisions that prohibit unreasonable restrictions on land use related to the installation of a solar collector system under certain circumstances. The bill specifies that a restriction on use is unreasonable if application of the restriction to a particular proposal, 1, increases the installation cost of the system by at least 5% over the projected cost of the initially proposed installation, or 2, reduces the energy generated by the solar system by at least 10% below the projected energy generation in the initial proposal. It also specifies actions that a community association can take in regard to the installation of such systems in common areas or common elements.
For discussion? Some motions for a favorable.
Motion.
Second. 7 okay being recorded in the affirmative?
Yeah.
Sorry. Senator Folden is down. Senator McKay is down. Senate Bill 566.
Senate Bill 566, as introduced, increases from $300 to $600 the filing fee that has to accompany an order to docket or a complaint to foreclose a mortgage or deed of trust on residential property. You have an amendment in your packet that would change that number from, instead of $600 to be $450. It was noted that this number is the cost if everything was taken in for inflation from when 300 was originally passed by this General Assembly.
Hold on, man. So that was on the amendment. So is everyone okay? So the amendment's now the bill's before you as amended. There's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative for the amended bill? Senator Fulton is down.
Anybody else?
Is everyone else okay? All right, Senate Bill 566 passes 10-1, as amended. James, sorry. 92, James is down. All right, Senate Bill 606.
Senate Bill 606 clarifies the circumstances under which liability for the failure to comply with existing statutory requirements relates to a tenant's right of first refusal to purchase a residential property. It's restricted to the owner of the property and does not attach to the property. This is a technical correction. It's not a substantive change. It was what the bill was intended to do, or the law.
Senator West, any question?
If I need to explain it, I will. Otherwise, I just move favorable.
Second.
Is everyone okay being recorded in the affirmative? 606. Take your time. Senate Bill 606 passes unanimously.
You could always amend tomorrow.
Senate Bill 856.
Senate Bill 856 requires the Maryland Department of the Environment, in consultation with the Maryland Department of Health, the Department of Housing and Community Development, the Maryland Department of Labor, and the Department of General Services to develop and update a centralized website that provides information about mold remediation and dampness, and two, an informational packet that includes certain resources. The bill establishes various requirements for landlords relating to mold and rental units, including performing a mold assessment and remediation. By June 1st, 2027, the Department of the Environment, in consultation with the other entities listed, must adopt regulations to establish uniform standards for mold assessment and remediation. There is an amendment in your packet. On page 4 of the reprint, or interlineated copy in line 9, currently it says a landlord has to give a tenant in a rental unit the pamphlet when the rental agreement is signed and every 2 years thereafter, and requires the landlord to request a tenant to sign confirmation of their receipt. The amendment would change this so there is no 2-year requirement, and instead the landlord gives the pamphlet upon request from the tenant. And then still on page 4 in line 18, as drafted, it would require the landlord to perform a mold assessment and mold remediation within 45 days after receipt of a written notice regarding the detection of mold from the local agency enforcing housing and livability codes or a tenant or building occupant. The amendment changes this to be that the landlord has to do their assessment within 15 days of that notice, and then, if the assessment finds mold, the landlord must do the remediation within 45 days after the assessment is completed, or if not feasible, within a reasonable time.
Let's just move the amendment so we can work off that. The amendment's moved, it's been seconded. Now the bill's before you as amended. Senator West.
Mr. Chair, I received today something from MACO asking for an amendment, but an amendment appears to be different from the amendment, and I haven't had a chance to compare the two. Can we hold this so I can compare the two and see what the differences are? Maybe the amendment we just adopted satisfies MACO, but
I'd like to, so if you could get that, we have to move this tonight because it has to go to Triple E.
Oh, okay.
Do you know the concept behind our amendment?
What, yeah, what is the, is anyone here from MACO or MML?
Is anyone in the back from MACO? Doesn't appear to be.
Is the sponsor aware of any MACO or MML amendments?
Referring to my staff, and I almost said, Your Honor. That's
There you
where my
go.
brain is right now. I've deferred to my staff. She said that we did speak with MACO and that their concerns were addressed in the amendments that were read.
Is that right?
That's what
Okay.
she said, but I don't know that we spoke to MACO today. I know that we had been in conversation with them.
I can read you the main substantive part of the amendment. It says, "A landlord that's a public housing authority or a similar entity shall comply with the requirements of subsection 1 of this subsection within a reasonable time period, considering the scope of the matter identified and the number of properties affected."
I'm not opposed to that. That's not in the amendments, but I'm not opposed to adding that to the amendments if we're able to adopt that verbally, Mr. Chair.
Could we adopt it verbally in principle and let council add it to the bill?
Just, yeah, hold on.
Yeah.
First, let's, so, if you could just bring it up here to John. Senator James.
I'm looking at MACO's written testimony, which might be quite dated and not deal with the most recent communication with Senator West, but did the amendments address MACO's initial issue concerning public housing authority and similar entities? We did that? Thank you. I see nodding heads. Okay, good. Thank you.
I just want to say thank you to the sponsor. We do a lot of stuff each year, and sometimes bills don't get the attention they deserve. This is one of the most important bills that we're going to do this session, and I just want to thank the sponsor for navigating it. When I have communities that I represent where this is a real problem, and mold is a little bit of the canary in the coal mine for bad landlords, right? We hear so much testimony about bad landlords, and there's no question there are bad landlords. But the way you know a bad landlord immediately is someone who is unwilling to remediate mold, and this bill goes a long way. So I just wanted to say thank you.
My understanding of what these amendments would do first, it would essentially is covered what this amendment is. This is saying, as drafted, added in, this would exempt a public housing authority or similar entity from the timeline of the remediation period as it was drafted, and say that they have a reasonable time period to do all that, depending upon the scope of their matter and the number of properties affected. This is now saying within that time period, but it also says if that's not feasible, they now have a reasonable time period. So I think that part is addressed. The second part has to do with the regulations that are required to be adopted under the bill at the very end of the bill. So this would be on page 5, the section 2, which is not, this is all about requiring certain regulations to be adopted. From what I can, instead of regulations, what they want is best practices adopted that would recommend these things instead of it being regulations. I don't know it wouldn't be a regulation then, so it would have less force, I guess. But other than that, I'm not sure about the second half of the MACO amendments.
We talked about that. Why don't you say regulations containing best practices?
Right, but it seems like they don't want it to be regulations. They're striking regulations.
They want it to be more.
Cautionary tale, the City of Annapolis Housing Authority was successfully sued by its residents because the city code said you have to inspect market rate housing, but you don't have to inspect public housing. So they successfully mounted a discrimination lawsuit against the housing authority and the city for having those two different rules of practices. I think we would run the same risk if we said you could, if it's a public housing entity, these regulations don't apply to you. We'll only have recommendations for you, but regulations for everyone else. So the beginning part, I think is totally fine, and like you said, in line with the bill, but the second part, I think we could come up with problems on fair housing.
I would, just to clarify, that the best practices is for everything that the regulations do. It doesn't.
Oh, no, that's unpalatable.
So
It's just to clarify, the second part about changing regulations to just best practices, it's not only about public housing, it would be everything.
And you guys decided against it? We did. Yeah. Yeah, so just reject the amendments. That's fine. They had to work, I mean, obviously, like, there's a difference between, like, which is probably the purpose of the, you know, so I think the work group discussed it and decided against that. That was a line of discussion that they decided to go against.
I would agree with that. I wouldn't want to carve out
Yeah, neither would I.
the local.
If you're gonna do this, you're gonna do it, you know what I mean? Like, let's, all right, so we are not gonna adopt those amendments. We have adopted the amendments before you. The bills before you, as amended, yes. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 856 passes unanimously with the amendment. All right, let's do the 349. We're now going to move on to Senate Bill 349.
Senate Bill 349 prohibits the creation of a lien on owner-occupied residential property by contract or as a result of the breach of a contract for payment of a medical debt. A complaint seeking a money judgment must indicate whether the judgment sought is for medical debt. Additionally, a complaint seeking a money judgment for medical debt must include the address of the primary resident of the defendant. If a lien is created in violation of the bill, the court must remove the lien and may award the owner of the property economic damages suffered as a result of the violation. The bill's provisions only apply prospectively to complaints filed on or after the bill's effective date. You have a amendment in your packet. On page 3 in line 17, it alters the definition of medical debt, which narrows the definition to be a debt owed by a consumer to a person whose primary business is providing medical services, products, or devices, or to a person's agent or assignee for the provision of provisions of medical service products or devices. The amendment further clarifies that the definition does not include debt charged to a credit card unless it is issued under a credit plan offered solely for the payment of healthcare services. Still on page 3, down in line 24, originally, if a lien is created in violation of the bill, then it's removed. The amendment removes the award of economic damages for the owner of the property.
Further discussion before we get into the amendments?
Fix the opposition?
Yes.
Okay, thank you.
Yes, we adopted the definition of medical debt that they wanted, and we narrowed the card issue to that which is solely used, a closed-end, unless the credit card is issued under an open-end or closed-end plan offered solely for the payment of healthcare services, and that's what the opposition wanted.
Okay, then move the amendment. Okay, it's been moved.
So the amendment has been moved, it's been seconded. Now the bill is before you as amended. Further discussion? Well, is everyone okay being recorded in the affirmative? All right, Senate Bill 349 with the amendment passes unanimously. All right, we're going to... Let's go, we're going to Senate Bill 896, and then we're going to, I want, just describe the bill and then do the two amendments. 30 seconds, I'll be right back.
Senate Bill 896, as introduced, requires that a landlord of any residential rental property provide a link to the property's pet policy on the property's website, in digital advertisements, and in any information provided for a residential rental search engine. A written copy or summary of the pet policy must also be included in any rental application form. The pet policy must state 1, breed and weight restrictions, 2, required fees, 3, limit on the number of pets allowed in the unit, 4, vaccination requirements, 5, liability insurance requirements, and 6, additional requirements for pet owners imposed by the landlord. There are 2 amendments in your packet. The one that is labeled Amendment 733624, that would remove the requirement to provide a link to the property's pet policy on the website in a digital ad or in any information provided for a residential rental search engine. Under this amendment, that would leave only the requirement for a landlord under the bill to provide the pet policy or its summary in any rental application form for a unit on the property. And then do I do the other one too? Okay, and then you have another amendment in your packet. This is the one that's labeled 833428. This one instead said that say that the bill only applies to a landlord who owns or operates 5 or more individual dwelling units in Maryland, and it also removes the requirement to provide a link to the property's pet policy in any digital ad for the property. Instead, it's just for any ad for the property.
Does anyone, well, the sponsor, what are you pushing?
I'll withdraw my amendment and go with the work group amendment with an amendment to the work group's amendment.
How does that work?
I'm not sure.
Could we get a group together?
I'm fine with the work group's amendment if we add back in, provide a link to the property's pet policy on the property's website. That to me is something very simple that they can do. They can just provide a link on their website. If they don't have a website, they don't have to put it on, then that's fine.
Out is the one 733624.
All right, I'll move that amendment. Is everyone okay adopting the amendment? Okay, now the bill's before you, amendment. Now Senator Love has an amendment to add in the website. Can you say it just one more time so we can adopt it?
Sure. It's adding back in C1, the numbers are all weird, 1-1. if that makes sense. Add back in, provide a link to the property's pet policy on the property's website.
One under Roman one, yes. All right, Senator McKay, question?
Yes. So, the website, is website defined and is using like Facebook Marketplace considered a website?
The property's website.
So using Facebook or using some form of social media would not apply?
I would not think so.
We did this before, remember? Senator Fulton, we argued about something like this last year. Yeah, we did. We've had so many lovely arguments. No, but do you remember we came up with something though? It was just
On this pet policy. Website.
I think it's fine.
Okay, as long as that covers that, that's fine.
Okay. All right. So is everyone okay? So just can you repeat the amendment in your line 20?
Sure. So this is Amendment 733624. With the amendment to this amendment, it would add back in what is on of the reprint, page 2, in subsection C1, Roman numeral I1. So it would put back in, providing a link to the property's pet policy on the property's website.
All right, I'll move the amendment. Second, is everyone okay? All right, now the amended bill is before you. There's a motion for favorable with the amendments. Seconded, is everyone okay being recorded in the affirmative?
I want to be voted. I just thought I could explain real quick. I'd like to explain my vote, and that is, we are getting entirely too involved in simple business decisions of small business. I mean, people want to know if there's a pet policy, they can call. But now we're adding another requirement that they've got to have this website, they got to have this link, they've got to have this. And we continue to hinder small business, so that's why I'm a no. Thank you.
Doesn't require a website. If you have a website, you have to put it on there. That is correct. But it does not require a website.
Thank you.
So what's the part about the link?
That was that Frederick.
I thought the whole idea behind this bill was so people could search and know if it was pet friendly or not up front. So if they don't have a website, part of the discussion was if you have Sally and Joe's, four condos, and if they don't have a website, you're saying they don't need it, but this would require you to have a written copy, right? Of a pet policy if you don't have it. A website.
It's part of the application. You're going to run a unit, you're going to want to know if there's a pet restriction.
Okay, I know this is I'm probably way overcomplicating this, but if you're already writing an application, you've already asked that you have a pet policy, so I don't understand what we're doing then.
What's the problem I'm trying to
I don't understand what we're trying to fix, other than if you're signing an application, you're there in person, it's not required to be unless they have a website, a link there. I don't understand what we're trying to fix, except put another mandate on someone to have an opportunity to justify, I don't know, legal standing that they brought an animal, and I'm confused now, completely.
Senator Love's going to tell us.
So go ahead, Senator. No, good. So you're explaining your vote, but go ahead.
If he's just explaining his vote, we can just move on. That's fine.
The bill's gone. I mean,
Yeah, okay, it's gone. I'm good.
no, I want to make sure everyone says what they need to say.
Yep, thank you.
Okay. All right, Senate Bill 150.
Senate Bill 150 alters various statutory provisions relating to the filing, maintenance, and transmittal of land records. The bill, 1, alters numerous formatting requirements, 2, authorizes the acceptance of documents received through an electronic recordation system, 3, authorizes court clerks to refuse to record instruments that fail to meet specified requirements, 4, authorizes court clerks to assess additional fees for the recordation of subdivision plats required by local law, 5, repeals certain requirements and references related to bound books and microfilm, and 6, makes numerous stylistic and technical changes. There is an amendment in your packet on page 3 in line 21. As drafted, it was changing the required type font to be 10-point font. That's putting it back down to 8. And then on page 4, instead of authorizing county court clerks to refuse to record instruments that fail to meet these specified requirements, the amendment changes that so that the clerk can't be held liable for a document that doesn't meet these requirements set above to be effectively scanned and recorded. So they can no longer refuse it. They're just not liable if they are recording something that doesn't follow these rules and it's not preserved properly.
So the amendments have been moved. Is there a second? All right, now the bill's before you is amended. Just for further discussion. Okay, so it's a motion for a favorable and seconded. Is everyone okay being recorded in the affirmative? Yes. Senate Bill 150 passes unanimously. All right. Favorable with amendments, 2 amendments. Okay, we're going to go on to. So this one's going to be a little bit longer. Senate Bill 63, which is Senator Muse's bill. So it's a number of amendments. So just
Senate Bill 63, as introduced, makes various changes related to the requirements for cooperative housing corporations, condominiums, and homeowners associations to fund reserve accounts. Among other provisions, the bill requires the governing body to prepare a specified funding plan and extends from 3 years to 5 years the amount of time after an initial reserve study that such entities have to attain the annual reserve funding level as recommended in the study. There is amendment in your packet. It is pretty extensive, so I'm going to go over it. Just as something up front, this is so long because cooperative housing corporations, condominiums, and homeowners associations are in 3 different places in the code. So everything that this amendment does, it just replicates it in each of those provisions. So I'm only going to go through the first one, cooperative housing corporations, because it's the same in the other 2 as well. So on page 2 of the amendment, line 7 is the definition of the reserve study. The amendment adds that the definition to include the list that clearly identifies the component of common elements that are responsibility of the common ownership community, in this case, cooperative housing corporation, to repair and replace, and that meet a minimum cost of repair or replacement as determined by the governing body of the co-op that is reasonably based on the co-op's expenses and is not a minor expense addressed in the budget. Page 2 and line 20. This fixes the definition because not everything is measured in square footage, so this is allowing whatever it is that the common element is being measured by to use the appropriate measurement. In line 25 and into the next page, these are just simply technical edits. Moving on to page 4 of the bill. It's an updated reserve study to the requirements that are currently in place. And then on page 5 in line 1, it removes the requirement that the reserves must include the replacement cost if it's greater than $10,000 due to the change in the reserve study definition that we just talked about. It's moving it to be a cleaner bill. In line 14, it requires the governing body to deposit funds in the reserve account on or before the last day of each fiscal year, and requires the governing body to review the reserves and the most recent study each year to determine if the funding is adequate. This was changed from accuracy because a lot of people in these governing bodies are not experts. So if they get something wrong, they're worried about being held accountable in some way. So that's why that terminology was changed. In line 19, it clarifies that this annual review is not a reserve study, and so it's not subject to those heightened specific requirements that are throughout the bill that we're going to talk about. This is simply just looking over to see if it's adequate. In line 22, this is expanding the ramp-up period to fully fund the reserve account after initial study from 3 years to 5 years. And then in line 26, this added language allows the governing body by a 2/3 vote to declare it is experiencing financial hardship and therefore can reasonably deviate from the reserve funding plan for 1 fiscal year, but the funding level must still at least fund essential components, which we will get to at the end of this bill. On the following page, at the top, it allows the governing body by 2/3 vote to extend the period for an additional fiscal year. And then subparagraph IV right under that requires the governing body to make good faith efforts to resolve that financial hardship and resume the reserve funding plan. The governing body has to maintain documentation about these good faith efforts and provide them for examination and copying upon request. And then in subparagraph Roman numeral 5, it requires reasonable notice to all members about financial hardship votes, and these votes can only be taken at regular or special meetings of the governing body. Starting in line 31, this is requiring the governing body to develop a plan to fund the reserves. In line 34, they took out fully because that is confusing for a term of art that is already used in the process, so we didn't want to confuse exactly what we mean by that. On the following page, in line 1, this is requiring the governing body to consider a number of ways to fund, and they have to select one of them. Down in line 8, the amendment allows them to choose any other funding method consistent with general accepted accounting principles. So they can choose one of these ones here that are listed, or if that is not working for them, they can decide to do whatever works for them.
Who's on the work with this?
McKay, West, and Sidmore.
Can you just give us like a 50,000 foot view of what this bill does?
Got it.
And if people have
Take care of the concerns of people that came in implementing the reserve set.
Yeah, so. Yeah, can you, who's pushing this bill?
This is music.
Certainly, thank you. We had plenty of testimony. If you remember, there were some concerned residents that this was becoming overburdensome for them and that they did not have the expertise. They were owners. They understood their responsibility, but they needed to figure out a better way to digest and make sure that these funding methods are all taken care of. And I believe that in the work group, we addressed all of their concerns that took into consideration of finding out the funding source method, not making them experts, but understanding their responsibility. Does that help?
Do this process, but doesn't make sure that it bankrupts them or is too financially hardship. It gives them ways to get around that and be flexible with whatever their situation is.
And still meet within the spirit of the legislation when it was passed. We haven't. Right, we haven't. And like one of the amendments, John talked about, they could pause it, but they had to get the money caught up. And that was, we felt was a reasonable time.
And they can only do that by 2/3 vote. So it's not just like people decide that 2/3 of the governing body has to decide that this is financial hardship. And it's only for one fiscal year. And then they would have to vote again if they need to extend it or not. And there is also a requirement that they need to catch up with that funding level when that is over.
Thanks. So when I first heard this bill, I put myself down as a yes. But we had a number of reserve study bills this year. And we've had other bills about condos. And those poor ladies came in several times. And they basically said, it's so complicated, it's so confusing, it's so onerous. That the impression I got from their testimony was they felt they needed to have a lawyer full-time on staff to tell them how to navigate all these complicated requirements. I liked Senator Attara's proposal for a study this afternoon. It seems to me that before we continue down the road of more and more complicated requirements on condominium owners, homeowners associations, co-ops, we should try to do a study and try to think in real terms for common sense people, what can we do that's going to protect them without requiring full-time lawyers to be advising them all the time? As a lawyer, I can navigate my way through this material, but most of the people who live in these condos, they're not lawyers. They're just ordinary citizens, and most of them are senior citizens. So that's my say.
Agree with you, but I also believe that we need to give the people that came down and testified some form of relief already. And I think the work group has gone through and addressed a lot of those issues to give it some relief right now. I yield to you that it probably does need to be studied, but I'm not sure how that's going to help people in the short haul for right now. It's going to have to wait another year before they're able to possibly, at least another year. I guess we could do emergency legislation, and there's always things around it, but I think that this, as amended, addresses their concern. It may not solve it 100%, but at least we're moving in that direction.
Moved. Now the bill's before you as amended. Further discussion. Motions for a favorable? All right.
With amendments.
With the amendments, yep. Second is, do we need any, roll call? Is everyone okay being recorded in the affirmative? Senator, yeah, you got it. Okay. Senator West is down.
I have myself as a
Senator Fulton is down. 9-1. All right, so look, we are. So. We're going to okay, real quick. So we're going to call voting right now. Because we need to get back on the immigration stuff for a work group. But we are a bill that's cross-assigned from finance. If John could come over. We're just going to have an explanation of the bill. We're going to give you a copy of the bill, and then it'll be before us to consider it during our next voting session. But I want to, since we've never had a hearing on it. It's a finance bill. So just familiarize yourself with it, and then we'll take it up tomorrow after people have had an opportunity to digest tonight. All right, if you all could just hang in there for a little bit longer, Bill, and then we're cutting.
Hi, Senators. My name is Nathan McCurdy. I'm counsel to the Senate Finance Committee. Senate Bill 43, for which you should be receiving a reprint, is a bill that is jointly assigned. The Finance Committee is primary. JPR is second. The Finance Committee voted on the bill this afternoon. It was a unanimous vote in committee with the amendments that you see reflected in the reprint. So I'll just go over it briefly, which is to say that Senate Bill 43 requires the Department of Health to establish a forensic review board at each facility that has persons committed as not criminally responsible. So the boards are responsible for reviewing and determining whether to recommend to the court that a committed person is eligible for discharge or conditional release with or without proposed conditions. And so the amendments to the bill first and primarily strike provisions related to the codification of a certain community forensic aftercare program. That program was the source of the fiscal impact that you'll see reflected in the fiscal note. So both the Department of Health and the Office of the Public Defender have sent letters saying that the bill as amended will have no fiscal impact. Further, the amendments establish additional notice, representation, and other requirements related to the submission of statements to the board. Additionally, requires a person's treatment team to implement any recommendations of the review board. And then finally, specifically authorizes the board to make recommendations related to the release of a committed person. So that's the bill and the amendments.
Thank you, Mr. Chair. So I just want to make sure I'm understanding what you're saying, because as I understand it now, for those that are found not criminally responsible, what is the process? Because how does this change from where we are now, where I think, is it just one doctor gives their opinion on the criminal responsibility, on the mindset, and this would create a panel, or no?
So my understanding from the Department of Health is that this review board within these facilities is fairly common, and that these boards meet to discuss whether to submit information to the court saying that an individual would be ready for release. But this would codify that program and require it at every institution.
I guess that's kind of my concern, is that does in here talk about what their forensic review board background, like a member is, their background is supposed to be in?
Yes.
It does?
Yep, on page 3, starting in line 1, it discusses each forensic review board shall have an odd number of members. Each member of the review board shall have 1 vote. The forensic review board, yes.
So the reason I'm asking is that having a friend who was shot by someone, and the person was deemed to be found not criminally responsible, it impacts this person and his family every day. So how does this bill change from what's in place now as far as releasing someone who's found not criminally responsible in the initial trial?
I want to back up to your first question because I cited to the wrong section. The bill does require that each member of the review board be a individual license under the health occupations article, but with respect to how it would change the particulars of your friend's situation, I can't say. I'd have to do some additional research. You're saying, is there an opportunity for victim input in this process?
Well, that's one. Is there an opportunity for victim input, and how does it change from where we are now? Because like right now, when they did the NCR on the subject, it was one person that did an evaluation on him. And that one person said, okay, he's not criminally responsible, so we're going to
Yeah,
we're
I
going to
think
put him.
it's
So
a different step in the process. I think what you're referring to occurred in the court. Is that correct?
it does.
Yes, and so this is about the forensic review board within the institution making a recommendation to the court about the individual's release. The court would still, this doesn't make any changes to the process that the court would undergo in evaluating that information.
Again, to my point though, we're having a group get together for whether or not they're okay to be released back in the public. Whereas we don't have a same process, we allow it to one person to determine if they're even eligible. You see my concern? So we're leaving it up to one person to determine if they're mentally competent to stand trial. But to release them back into society, we're having this board. My question is, why wouldn't we have it at both sides?
So this counsel, I don't want to make him like,
Oh, I'm sorry.
just describing the bill, but I don't want to make, it's not a I don't want to make sure, he's not getting into policy territory.
My apologies.
We can talk offline.
Yep.
No, so I don't want to,
No,
sorry
I'll
about
just
that.
bring up an amendment. It's fine.
Okay.
Thank you.
Senator James.
Thank you, and I'm also not trying to press you, but we heard a very compelling bill from Senator Quarterman about a very tragic mass shooting out in western Maryland where 3 people were killed. A police officer was gravely injured but did not die, and several others were also wounded. And several of the family members have come down before us before, and this year just one person did. Troubled by the analysis by one individual that the purpose was found not criminally responsible. I think at the commission of the crimes, right? Not the stand trial. So my question is sort of similar to, not to get into policy, but the board, and since I'm very unfamiliar with this area, but I've done a lot of research and I'm educating myself to try to figure out how we can improve the process. Is it true that that we don't have any kind of process similar to the one you're envisioning here on the front end? In other words, there's no review board or commission that determines whether an individual will be eligible to make that claim to the court that they're not criminally responsible at the commission of the crime. Is that, or do we? I do not know that front-end process, and I'm just trying to figure out.
Senator James, so again, I'm counsel to the Finance Committee.
Oh, I know, but I thought maybe you did a little
understand your
research.
question is related to a criminal procedure issue, which is not.
No, just the forensic side. In other words, we're creating a board. Do we have one already that is engaged when someone gets committed under that criminally not responsible? Are you aware of that or not?
I'm going to kick it over to counsel, Senator, go ahead, counsel for.
Hi, Senator.
And then it's a yes or no, and then I'll just figure out the rest. Thank
So
you.
as I
Sorry you
understand the
don't have
question,
answer.
and I actually am not going to have an answer for you tonight, but I do want to look into it for you. Just so I can, is the question about what the process is on the front end of an NCR case in determining?
Well, that's very broad, and I'd love to know that, but I just was trying to figure out, because I thought maybe this language was modeled after something that already exists, perhaps at the front end. But so that was sort of my question. Do we have a similar process that we're modeling this after on the front end or elsewhere, I guess, with that, in that umbrella of criminally not responsible, either the commission of the crime, criminally not able to be held accountable in court, or whatever that standard is, and then this one is, where are you once you've been committed, when should you be allowed out? So I guess we have 3 areas in which that can occur, and I'm trying to figure out whether in any other of the other two areas, do we have something like this?
Yeah, let me, I want to give you good information.
Thank
Would you mind if
and
we
I'm
followed
sorry
up
to put
after
the other person on, I didn't,
No,
I thought maybe you knew about it.
Yeah, I want to be helpful here.
Right.
I guess, could we follow up after the voting session, and
Yes,
I can make sure I'm
apologize.
getting you the
I thought
right
it was going to
info?
be an easy answer and didn't realize it's going to be more challenging. Sorry about that. Thank you.
Here to help.
Sure. Thank
Hey,
you.
appreciate it. Thank you so much. Thank you. All right, so review the bill over the night. If you have questions, draft them up. Maybe get them to council ahead of time, and then we can move on the bill or not. All right, so we're gonna gavel out of voting. Josh, you and I, we gotta get on the immigration stuff. Tomorrow, we're not gonna vote before the floor tomorrow, but we are going to vote, we have 2 floor sessions tomorrow, and from what I understand, we have 2 floor sessions on Thursday.
Friday.
Or Friday as well? Thursday?
Just Thursday.
Just
Thursday's gonna be a long session.
All right, so then, so the point is, tomorrow, just plan for, we're gonna vote for a long time tomorrow. Yeah, yeah. After session.
Before the second session.
I'd like to talk to you after you have a second, I got that answer.
Okay, that's good. Okay, so with that, we will gavel out, and we'll see you tomorrow on the floor.